Hello, everybody. How's it going? Happy Sunday. I started talking and I hadn't added myself to the stream, so that was great.
Oh, hello.
Hello. Hey, Recliner Detective. Hey, Allie79. Hey, Tony. Hey, where's Kenny? Hey, Lupe. Hey, Sam. Hey, Renee New. Whew. Well, it's Sunday. We made it through the weekend. Yeah. Everybody get ready for Monday, I guess. I'm not ready. It's chilly here and I'm not pleased. I don't like it at all.
Oh, jeez. It's nice here today.
Yeah, it's chilly today and I don't really appreciate it. Not impressed. Kind of tired of it. Shmita, where are you?
I'm here. Hi.
Hi.
I pulled a Teresa and I shoveled food in my mouth just as it was done.
Oh, no. I'm sorry. Hey, Dee Dee. Hey, Amelia. Oh, all right,
everyone.
All right. So Teresa will be here in just a few. So tonight. You were West Coaster, eh, Kenny? Okay. I forgot what I was gonna say. I don't remember. Oh, Teresa's gonna be here in a little bit, and tonight we're gonna do the verdict, the sentencing, and then the whatever the motions were for the new trial. So we're gonna hear all that, and then tomorrow night I'm gonna put something together for everybody so we can hear some testimony from Tristan, from Todd, and the forensic pathologist, because we all last night were left with some questions. And so we'll do that. And then Tuesday, we're going to start the Ezra McCandless trial. So I'll have a whole new video. I already have like a whole concept in mind that I'm excited about. So, and then I was thinking, keep an eye out on the community tab, because I'm going to put up a poll, but I'm going to make it, I just want to get you guys a little bit of feedback from you guys about something I'm thinking about doing. And depending on how you guys answer or whatever, I'm either going to do it for everybody or I'm going to do it for the members, depending on who all is interested. If I have more members that are interested in me doing it, then that's the way I'll go. But if everybody is interested in it, then that's what I'll do. Oh, it's I'll put it in chat for you. Recliner.
Yes, and you're going to be very shocked at the difference from her trial to Todd's trial.
I think that's how you spell it. I'm almost positive.
Well, it's MCC,
Oh,
but that's close enough.
let me fix it so y'all can Google it. What? It auto-corrected it again. What the heck? There we go. That's better. There we go. With this, what do you mean, Shmita? Like, I figured we would watch all the things tonight and then just say what we feel.
Yeah, that'll be
No,
our
I mean in the
deliberation.
real trial. Like, how long did that jury deliberate?
Oh, I don't know. I
Okay.
I don't
know.
know either.
I'll Google it real
Google it.
quick. Oh, you're gonna Google it, Shmita?
Yeah,
Okay.
I can Google it. I was just
All right.
curious.
Yeah, I don't know how long it was. I'm kind of curious about that myself. All right.
I don't think there's any volume at first.
No, I know, but I had it muted at first.
Okay.
I just had to make sure.
Well, I was thinking it too. I was like, oh no. Then
No,
I
I had it
remembered.
muted. I had it muted. All right. Now I'm gonna speed it up just
I'm
a
still
little
looking.
bit.
It's very vague on here. Like, it's just like,
Okay, the
oh, the
record should
jury
reflect that it
couldn't
is 2:30 p.m. on
come to a
Monday,
conclusion on
September
Friday.
23, 2019.
So I assume that
I've been
means
informed by the
Saturday,
court
but like, I
attendant that
want
the jury has
hours.
reached a verdict.
Hold on.
The jury is not back with us yet. I want to inform everyone of a couple of things. First of all,
3 days,
again, any
Shmita.
cell phones, electronic devices,
The answer
anything
to
like
your
that,
question
turn
is
them
3
off,
days.
Put them in your pocket. If law
Oh,
enforcement
dang.
or security sees anyone
Hey,
using
Rita, how
any
are you?
electronic device,
Welcome.
it'll be
Thank you
taken
so
from you immediately.
much.
Secondly, this is unquestionably an emotional case for both parties. When the verdict is read, I expect there to be no outbursts, no disruptions of court of any kind. For those of you seated, stay seated. Don't stand up. If you stand up, law enforcement will be very close to you very quickly. I want this proceeding to go without any problems, any issues, any commotion of any kind. Okay, let's go ahead and have the jury brought in, please. Please be seated, everyone. Okay, for the record, we are back in the courtroom. The defendant is personally present. All of the attorneys are present. The jury has now joined us. I am informed that the jury has reached a verdict. Would the foreperson please hand the verdict to the court attendant?
Hang
Okay,
on
this
a
is the state
second
of Iowa
before
versus
this
Todd
gets read.
Mullis,
I want to say something
Delaware
really quick.
County case.
Okay, so this got me thinking when Shmita asked how long they deliberated. You know, I was under the impression, I guess I didn't really understand the deliberation process, but as I understand it now, different states have different rules for deliberation, meaning they don't deliberate 25/8. So, like some places it's an 8-hour day for deliberation, and some places it's like 6. So that's how it goes. So if it was 3, I only remember it's 3 days for this one, only because I remember when the judge ended it yesterday, he said the 20th of September.
Oh, okay.
Oh no, Lupe, they'll be
Okay.
alive tomorrow. We're gonna do some this is as loud as it goes, Kenny, I'm sorry. Let me make sure.
Okay, so the New York Post says jurors came to their verdict after about 7.5 hours of deliberation spanning 2 days.
2 days. Okay.
So that's, I don't know, New York Post. So
Well, I mean that's probably right.
Sorry, where's Kenny? I found the volume button on my movie maker, so the next one should be louder.
All right, here we go. Yeah, this is
I
as
hope
loud as it
Teresa
goes,
makes
babe.
it before the sentencing.
She'll be here. She's probably listening, babe.
Okay.
FECR 012941. We, the jury, find the defendant, Todd Michael Mullis, guilty of the crime of murder in the first degree, signed by the jury foreperson. Is the defense asking that the jury be polled? Okay. Does the court attendant have the jury list? Go ahead, let's poll the jury at this time.
Is this your true and correct verdict? Yes. 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 Or is this your true and correct verdict?
See, there you go, Mo. If you'd have been pressured, you could have said, right, here's your last out.
Correct verdict? Yes.
I
Or is this your true and correct verdict? Yes. Is this your true and correct verdict?
have seen that
Is this
happen
your true
once.
and correct verdict? Yes.
There she
Okay,
is. Hi,
ladies and
Teresa.
Yeah,
gentlemen,
they
I'm going to
did
dismiss
it
you in
in,
just a moment here.
hold
I would
on a
ask that you
second.
go back to the jury.
They did it in oh goodness, what is that girl's name?
Was it the Groves case?
No. It's where they set her on fire. Jessica,
The cheerleader?
I don't remember if she was a cheerleader.
The one in Texas, the cheerleader they set her on fire that her friends did?
No, this wasn't in Texas. This is a recent one. Jessica Chambers.
Hmm.
When they polled the jury, he said, no, this isn't my verdict.
Yeah, I remember it happening, but I didn't remember who.
Yeah, Jessica Chambers.
Okay.
The court attendant will collect.
I'm
the
sure it's
badges,
happened in
make
other
she
ones.
collects your notes so that those can be destroyed and you can get your possessions and your belongings. I would ask that you wait for just a few minutes. I will come back there and talk with you. I do that in every trial, give you the opportunity to ask questions, lodge any complaints that you may have, or give any advice about how we can make things better for jurors in the future. So I do want to thank you again. I know the attorneys have thanked you. We thank you for your service. This is critically important for how our system of justice operates. And at this point in time, I will discharge you and send you back to the jury room. Please be seated, everyone. Okay, for the record, the jury has been excused. The defendant is advised, based upon the jury's finding, that he has the right to file a motion in arrest of judgment and a motion for new trial pursuant to Rule 2.24. Mr. Mullis, your attorneys can explain that right to you. Pursuant to statute, you are not to be admitted to bail pending sentencing, and we will set a sentencing hearing in this matter. I'll talk with the attorneys about the issue of waiving PSI, which I presume will happen, and about picking a day that is mutually agreeable to the parties to set the matter for sentencing. Is there anything else the state needs to do on the record today? Anything from the defense on the record? Okay, we'll stand adjourned. Thank you, everyone.
I'm just curious why we watch this, because I don't have a whole lot of experience watching trials from other countries, but I want to ask the chat. When a person in your country, if you're not from the United States, is found guilty, and they take them to the jail or wherever they're going to take them, do they get this kind of treatment? Are they shackled like this? Do they have 1, 2, 3 officers escorting them from the courtroom? I'm just curious. I just like to know what other places do.
I don't know. I don't think so. Not here, anyways.
So
is Canada another country?
is the Canada's another country?
It's weird
I'm just
though.
kidding, chat.
His family just looks stunned. Like, I wonder what they were thinking though.
Like they haven't even moved.
No, like no tears. No, look at them. Oh, look at he decided to look over now. But
That one guy is just loving being on the camera right there.
I need to know why he's so much more tan than the rest of them. Are you getting in the tanning beds after the pigs are done?
That has to be so hard because they were all family.
I know. And but they still are because they have grandchildren in common. Those are regardless, those are still their grandchildren.
Right.
Who's that guy right there?
I think that's Todd Mullis.
special agent.
That's
That's who he is.
yeah. The one they were hugging. I thought you were asking about the older gentleman. I think that's Amy's dad.
Yeah,
they
that,
all
yeah,
just
that,
look pissed.
well, they
Look at
have,
the way
they,
they're
they probably
looking at
are.
him. They're looking at him like, what the fuck just happened?
Yeah, his
Yes,
mom
Luke,
looks like
they-
she wants to kill him.
Yeah, they found him guilty of first-degree murder. Did I answer you earlier about what we were going to do? We're going to be live tomorrow, babe. We're going to do a recap on this case. I don't remember if I answered that sufficiently. Sometimes I answer part of it out of my mouth and the rest of it is in my head and doesn't
I
come
do
out
that
of my
all the
mouth.
I do that all the time. I respond to people like in my head, and I think I responded to them, and somebody will be like, "Why didn't you message me back in like 2 days?" And I'm like, "I did. What are you talking about?"
I do that too.
Hey, Max,
Okay.
2002.
Here's
a
a sentencing with his new lawyer.
that doesn't know how to put his mask over his nose. Okay, I can see where this is going already.
Oh, jeez.
Where's the sentencing?
Right here.
Right here.
This is sentencing.
Oh, so he has a different attorney with sentencing.
Yeah, he
Yeah,
already has
that's
his
what I
Yeah,
own
when
asked
he
attorney.
got convicted, he booted that lawyer to the
Okay,
curb.
okay.
They were already in motions appeals or appeals motions.
They
Whatever way
filed
you want to
them.
go with it.
They filed them immediately, right? As soon as the
Right.
verdict was read.
Mhm.
Okay.
Yeah,
We're,
so he got rid of that attorney and got this dude.
okay. Hey, Crackling Rosie, True Crime. We're still
And-
covering Todd Mullis. This
And
is
his sentencing was postponed to like 4 times due to COVID.
oh my goodness. This is Todd Mullis's sentencing.
Dang you, Shmita. Now that's all I can see.
I can see it everywhere. It's like my eyes just
Oh, you would
focus.
die at work. Everybody wears them on their chin
Why? Why even? Where?
because it's required, but so everybody just pulls them down to their chin.
Does the attorney have glasses?
No.
I think he
What?
did.
I think so. Yes,
That's a big problem with a mask when you have glasses because it fogs up your glasses.
it
So
does.
I know.
a lot of people with the glasses will have it below their nose because then it doesn't fog up your glasses.
Right, because I have to wear safety glasses at work and I'm always foggy.
So I believe, Kenny, if it's COVID, then the sentencing's got to be in 2020.
No, I think it's still 2019.
See,
I don't know.
see,
You'll have to look that one up, but I
The
think it's still
vid-
2019.
the vid messed me up completely. I've lost like the end of 2019 and all the way through the end of 2020, pretty much. Plus, I was on that.
Yeah, when
I
did it
thought
come? I
the
don't even
vid
know how.
was until March. of
Okay, so then it has to be 2020. You're right.
Yeah,
That's why I was like, wait a minute. What year? I don't even know what's going on anymore. I
Yeah,
really should just
yeah,
mute
March
and
of
just sit here and look
2020.
pretty.
Yeah,
I was at
okay.
Jen's house when the vid hit.
Yeah.
I couldn't hardly get home.
I was going to say something else vid related, but now I don't remember.
Can somebody look up the date of the sentencing? Because now it's going to bother me.
All right, I'm
It's
going to
gonna
look.
bother me.
I'm
It's
going to look.
March.
Well, then why did his sentencing keep getting postponed? Because it was 2019, and I swear the article I read said it was postponed 4 times due to COVID.
Well, let me
Well, it
look
was
it up.
scheduled on December 17th, originally, apparently, of 2019. After being delayed due to COVID, the sentencing hearing for Todd will be on Friday, September 4th, 2020 at 2.
Yeah,
Okay,
that makes sense.
there we go.
In this
Okay.
matter, on September
It was
16,
scheduled for March
2019,
17th. And
But
then
why was
before
it
that,
postponed
was-
December of 2019? There was no COVID.
Maybe a new lawyer
The charge of murder in the first degree.
asked
The
for more
defendant
time.
has filed a
Hey,
motion for new
Gwenty.
trial and motion in arrest of judgment, filed on November 4, 2019, and a second
This is important.
on February 28, 2020. The second motion was filed with the court's approval as to timeliness. The state has filed responses to those motions. The matter is scheduled today for hearing on the defendant's motion for new trial and motion in arrest of judgment. I have read and printed the motions, the state's responses. I will say for the record that all of the pleadings by both parties will be considered as part of the record today for purposes of post-trial motions. Counsel can make argument on those motions and supplement them at this time if they would like. Mr. Hamrock, it is your motion. Do you want to go first?
Thank you, Ron. Yeah, please support counsel and Mr. Mullis. Judge, we did file a brief in this matter. I'm glad that you've incorporated that with all the other pleadings. I do want to touch on a few items that was contained within our brief. First of all, Judge, the first item we'd like to talk about would be prosecutorial misconduct during the course of the trial itself. As we've set forth in our brief, Ms. Hughes, one of the prosecutors in this case, did in fact play the 911 tape. She asked questions which can be found in the transcript at page 88. And the question or questions that were asked by Ms. Hughes are, first, she says, "Now, Todd, here I'm going to play you the part where you're doing the chest compressions, and I'm just going to ask that you listen in between the chest compressions, okay?" And then plays the 911 call. "Now, Todd, did you just hear that whisper at the end of that?" He answers, "Yes." The question, "And what did you whisper?" He answers, "I couldn't hear it." "Okay, I'm going to play it again." Question, "Todd, do you whisper 'cheating whore' right there?" Todd says, "No." "So you don't remember what you whispered?" "No." "Okay, I'm going to play another clip for you." Plays the 911 call. "Do you know what you whispered there?" "No." "Did you hear that? So I'm going to play that part one more time." Next question, right there. "Do you say, 'Go to hell, cheating whore'?" Todd says, "No." "So you don't hear that?" He says, "No." "You didn't hear at 6:53, cheating whore. You didn't hear that." "I didn't hear that word. It's right at the end after you hear a ping. You don't hear, 'Go to hell, cheating whore,' and the answer is no." After the conclusion of this trial, counsel had the tape reviewed by an expert company. And the fact of the matter is that none of those statements were contained on that tape. So in looking at this, Your Honor, the question is, did Ms. Hughes intentionally, recklessly, and repeatedly use prejudicial terminology while she knew or reasonably should have known this phrase was not in the recording that was played? Were questions distorted to get distorted testimony, making unsupported statements during her closing argument, diverting the attention away from the actual existing and presented evidence? So to prove prosecutorial misconduct, we must show the prosecutor acted with reckless disregard, and that's contained in State versus Leadham. Also, the Iowa Supreme Court has set forth in State versus Schlitter to specifically note that conduct by a prosecutor that deprives a defendant of a fair trial is prosecutorial misconduct within the confines of the law. Further, the court specifically identified examples of prosecutorial misconduct, including questioning witnesses about others' deceit, distorting testimony, and this is the important one, making unsupported statements during closing arguments, stating the defendant lied during testimony, diverting the jury from deciding the case based on evidence, making other inflammatory or prejudicial statements about the defendant. That's what happened in this case. By asking those questions, knowing that those statements were not contained on that audio tape, I think rises to the level of misconduct. Now, I expect to hear from the government that jurors were interviewed, at least a juror was interviewed after the trial in this case. And that juror said that, well, we were on both sides of the fence, or we were undecided, meaning some probably thought that was said, some didn't think it was said, but they couldn't come together, so we disregarded it. Well, the problem is, I wasn't in that jury room, the court wasn't in the jury room, the government wasn't in the jury room. We don't know what the jurors talked about. We don't know if they actually, all of them did disregard it. The jurors have not been placed under oath and asked these questions. That has not happened. So it puts us in a position, Judge, where the only way that we can right the wrong that took place at trial at this point in time is going to be to grant Mr. Mullis a new trial in this case, along with further instruction. The next issue that I would like to talk to the court about today is going to be whether or not Mr. Mullis received effective assistance of counsel during the course of this trial. Now, Judge, Mr. Mullis has always maintained that this was an accident. He has never come out and said that this was a murder ever. Second, he never told his counsel at the time that they could concede an essential element of a crime that Mr. Mullis has been accused of committing. And what happened in this case? Well, during the opening statement, the fact that this was a murder and the jury has to figure out who did it, was conceding an essential fact or an essential element that the government would have to prove beyond reasonable doubt to the jury. Now, that's important because there's a United States Supreme Court case, McCoy versus Louisiana. And in that case, the Supreme Court, under Head Note 6, goes on to say that numerous choices affecting conduct of the trial do not require client consent, including the objections to make, the witnesses to call, and the arguments to advance. The court goes on to say, though, that counsel in any case must still develop a trial strategy and discuss it with the client. The court goes on explaining why a lawyer needs to say why, in their view, conceding guilt would be the best option. And that did not happen in this case. To further advance that notion that it didn't happen, on July 7th of this year, Todd Mullis was involved in a probate proceeding, probate hearing that was under oath. And we've attached this as an exhibit to our brief. During that time, or during that hearing, Todd was represented by his counsel, and the estate was represented by one attorney, William Strong. Now, during the course of cross-examining Mr. Mullis, so these questions were not asked by his lawyer, they were asked by the lawyer for the other side. So during cross-examination, back July 7th of 2020, the question was asked by Mr. Strong of Mr. Mullis. And I quote, "And I believe during your criminal trial, you took the position that Amy was murdered, but it just wasn't you. Do you recall that?" Mr. Mullis, under oath, says, "I never said that." The next question. "Well, I believe that was evidence that your attorney asked you during the criminal trial. You don't recall that testimony." There's an objection, and the question gets reread, and Mr. Mullis answers, "I never gave my lawyer the request to state that." Meaning, I never asked my lawyer to concede that this was a murder and just take one of the elements that the government would have to prove beyond a reasonable doubt out of the equation. We have it under oath. I think that with the guidance of the United States Supreme Court, what we have Mr. Mullis saying, how this case went, because once an admission to a murder is made in an opening statement, you can't put that back in the bag. That's out. The jury's already believing that this was somehow a murder and that they just have to decide who committed it. Once again, the only way that we can right this wrong is to grant Mr. Mullis a new trial. Last, I want to talk about the totality of the evidence that came in, viewed in the light most favorable to the government, which is how the court has to look at this. Was there enough to convict Mr. Mullis? And what we have to look at is what happened on November 10, 2018. Well, we know that on that day, Todd Mullis, his original plan was to go and do what's called chisel farming. He was going to go to a different property that they either rented or owned, and he was going to do some work on the ground to get it ready for the spring crops. The ground was too frozen, as it turns out. That particular day was too cold. Mr. Mullis then goes back to his house where he and Amy and Tristan, his 14-year-old son, have breakfast. After that, Mr. Mullis and his son Tristan decided that since he couldn't do the chisel plowing, that they would go hang heaters in the hog barn that's located on their property. Amy decides that she wants to come out and potentially help and do whatever, so she goes out as well. Amy, had a procedure a day or two before and wasn't feeling all that great, so nonetheless she goes out. They're there, and how this barn is set up is that it is a barn that runs east and west, and there are 3 entrances into this barn. There's the main entrance on the west end of the barn, which you walk into what I call like an open office setting. It has some tools hanging there. It has what else becomes very big in this case. It has a water spigot and a garden hose in that little area. There's a window in that area that looks out down to the east so you can see into the hog barn itself. Just a few feet away is a doorway where you would enter or walk through to get in to the barn part itself. The only other entrance on the west end of the building, you would have to walk up a ramp, and it's like that because that's where semis would back up to that door that's elevated off of the ground for hogs to travel in and out of the barn. The last entrance or exit is clear on the southeast corner of the barn. This barn is about 100 yards in length for where the cattle can be. Tristan and his father were working on the west end. They were starting on the west end, going to work their way towards the east, hanging these lamps so that when they got the small hogs in, they would be warm during the winter months. Now, Amy decides that she's going to go back into the house, and somehow it comes up, I think maybe Todd asked her if she could grab the cat carrier out of the red barn, which would be located to the west and to the south of the hog barn. So Amy leaves, and they don't see her. They continue to work, and it's at least 15 minutes, if not a little bit longer, before Tristan says he's thirsty and he's going to go around the corner and get a drink of water. So he leaves to go around the corner and get a drink of water. Now, as he's standing there getting his drink, he doesn't see Todd Mullis walk by him and go out the west side door. He doesn't see Todd Mullis go up the ramp, open the hog door, and jump down to the ground. All right. The only other way this could have happened, and it's impossible that it did happen, would be that Todd Mullis would have to sprint 90 yards to the east, over to the east door. Todd Mullis would then have to exit. And bear in mind that this is 15, 20, maybe longer minutes later. Todd Mullis doesn't know where Amy is located at. So whether she's in the red shed, whether she's in the house, he doesn't have any idea. So then that means that Todd would have to sprint 100 yards back to the front or the west side of the barn. And then the red barn is located approximately 30 yards away. So they'd have to sprint 30 yards over to the red barn. He then would have to commit this criminal act that he's been accused of by finding a pitchfork or corn rake and then put it down, then sprint 130 yards back to the east to that door, sprint another 90 yards once he gets inside back to the west, start working on the heat lamps, not be out of breath, be perfectly normal, all while Tristan left to go get a drink of water and come back in. It would be physically impossible for him to do that. That's the only time that I believe that he was out of, except for maybe one other drink, which was short, that they were out of each other's eyesight as they're working in the bar. It wasn't until Tristan leaves to go find mom that he finds mom.
See, Todd's over there nodding his head like, yep.
Loudly, whatever the case may be. Todd
Yes,
hears,
all
and
things we
Todd
said
goes
too.
over and
Uh-oh.
Oh no.
for that reason, and for all of the other reasons that I've talked about today, the only way to make this right for Mr. Mullis is to grant a new trial. And our reasoning and facts for the motion and arrest of judgment are the same, so I'm not going to reiterate everything for the motion and arrest of judgment. So in the end, Judge, we are asking that this court grant a new trial, allow us to proceed to trial, and present our evidence. Thank you.
Okay, Ms. Hughes, you want to go ahead and offer the state's argument?
Yes, Your Honor. As you are well aware, Judge, a court may grant a new trial pursuant to Iowa Rule of Criminal Procedure 2.24, subsection 2, subsection B, subsection 6, when the verdict is contrary to law or evidence. The language contrary to evidence means contrary to the weight of the evidence. In ruling on a motion for a new trial, the court may weigh the evidence and consider the credibility of the witnesses. In the current case, the state proved beyond a reasonable doubt all the elements necessary for murder in the first degree. The verdict was consistent with the weight of the evidence, which showed the defendant committed murder in the first degree. As Your Honor is well aware, the decision to grant a new trial is within the discretion of the court and should be exercised with caution. Your Honor, with regards to the motion, the second motion for new trial and motion in arrest of judgment filed by the defense, I will briefly talk about the 7 different issues or points that they addressed. The first one being prosecutorial misconduct. The defendant takes issue with what I indicated and what I believed then and still believe the evidence showed. But it is the state's position, Your Honor, that even if the jury did not believe that's what the tape said, I very deliberately and several times instructed the jury during closing to decide what they believed the tape stated. In fact, Judge, I told them not to listen to what I said or to what the defense attorney said, and I advised them to decide that for themselves. Additionally, Your Honor instructed the jury that questions and statements made by the lawyers are not evidence and are not to be considered as such. You not only instructed them on that, Your Honor, but you also included that in the jury instructions in writing that were given to the jury. And those are the same instructions that were given to the jury that they used in deciding their verdict. As Your Honor is well aware, a new trial based on prosecutorial misconduct is only warranted when it is so prejudicial as to deprive the defendant of fair trial. The defendant bears the burden of showing both prosecutorial misconduct and prejudice. The defendant did not do that in this case. With regards to the second issue addressed by the defense, it discusses improper expert testimony by Deputy Hemaseth. First, Judge, it's the state's position that an issue such as this cannot be raised for the first time in a motion for new trial. I do agree that the defendant objected to the Google searches coming into evidence, and that was an issue that was litigated prior to trial that Your Honor appropriately ruled on. However, to the best of the state's recollection, the issue of Deputy Hemaseth actually going through those searches was not objected to at the time of trial and cannot be raised now. But nonetheless, Your Honor, Deputy Hemaseth's testimony was proper.
Yeah, it was moved to Dubuque County, and the crime was done in Delaware County.
Oh,
The
okay.
defense properly
My
addressed the
bad.
issues they had with the times on cross-examination, which was the appropriate way for them to challenge the evidence and to subsequently make the proper arguments that apply. But Judge, the bigger issue with regards to what the defense brings up is that the state did not offer Deputy Hemaseth as an expert witness. He testified as a peace officer and as a lay witness. I know that, Your Honor, he testified regarding the Google searches. The Google searches already came into evidence because of what Your Honor ruled in a prior motion. And they came in because the state presented a letter of authenticity from Google. So the searches were coming in. Deputy Hemaseth did talk about them, and that was the manner in which we decided at that time to publish them to the jury. And the defense made a big deal about the UTC time. Again, that goes to the weight and not the admissibility. The searches were relevant because of the content, not because of the time. And furthermore, Judge, the jury again was instructed by Your Honor in the jury instructions that they are to decide the credibility of witnesses. And I know Your Honor is well aware with the instructions that were given in this case and the credibility of witness instruction that's given in criminal cases all through the state of Iowa.
Thank you, Rhea.
That to the jury that in
Welcome
determining
to the
facts,
50-1100
you may have to
Club.
decide what testimony you believe. You may believe all, part, or none of any witness's testimony. And again, the jury used those instructions when they decided their verdict. In the defendant's motion and briefly in their brief, they also talked about improper hearsay testimony, but that was not addressed in detail. But Your Honor, the state would just say that you made appropriate rulings in the pretrial motions and during trial regarding what statements were admissible. This court has not misdirected the jury in a material matter of law, nor erred in the decision of any question of law during the course of the trial. The state contends that the challenged legal rulings made by the court in the context of the trial were made correctly, and no legal grounds exist to set aside the verdict in this case due to any alleged legal error. Your Honor, I'm going to address point number 4 and 5 that counsel made together. It was 4 and 5 in the motion, and then today talking about ineffective assistance of counsel. As Your Honor is well aware, there's a controlling case from the Supreme Court of Iowa, State v. Trane, T-R-A-N-E, which is the controlling case that talks about claims of ineffective assistance of counsel. And this, the Supreme Court made this ruling and decided this case in October 2019, and it explicitly states in that ruling, the only avenues for raising an ineffective assistance of counsel claim are post-conviction relief and direct appeal. The claim may not be raised via a motion for new trial. Judge, based on this, these are not appropriate claims or a reason for you to grant a new trial.
She's actually wrong on that because that was in November of 2019, and he already made the appeal prior to November 2019. So her case law would be wrong.
Correct, because it would be, yeah. There's new case law.
Right. But
Yeah.
you can't put new case law to an old motion. The old motion, when it was filed, would have to be done under the laws and under the case law of when the motion was filed.
Correct. Not new case. Yeah. Gotcha. Excellent point, Teresa.
Before the power to grant a new trial on the ground that the verdict is contrary to the weight of the evidence should be invoked only in exceptional cases in which the evidence preponderates heavily against the verdict. The verdicts of guilty in this case are not contrary to the law. The witnesses and the evidence the state presented all establish the elements of this charge. As I indicated, the evidence in this case simply does not preponderate heavily against the verdict, and there was no miscarriage of justice that resulted from the jury's verdicts in this case. Your Honor, this is not the extraordinary case.
Hey,
where it's your job
miscellaneous.
to overrule the jury's roles and verdict. Your Honor heard the testimony, you observed the state's evidence, and was able to judge the credibility of the witnesses. The evidence in this case was overwhelming, and the defendant was found guilty of murder in the first degree because that's what the state proved. The last thing that counsel talks about in his motion is that the defendant did not receive a fair and impartial trial. And I believe that's what he just briefly discussed about the totality of circumstances. Again, Judge, I believe in his motion, he referenced his prior arguments, pretty much indicating that the verdict is contrary to the evidence, which we've already addressed. What counsel just did now was start giving you a second closing argument, and that is not what a motion for new trial is for. What he just indicated to you was what he believed are the facts in this case. He was indicating facts at the end of his argument, all factual determinations that were made by the jury in this case. That is not the correct avenue for a motion for new trial. We would ask that you deny the defendant's motion for new trial as to every issue that was raised.
Mr. Hamrock, it is your motion. I'll give you the last word if you have anything else you want to add to your argument.
Thank you, Your Honor. Judge, inflammatory statements. The questions that were asked on cross-examination of Mr. Mullis were highly inflammatory. And furthermore, it didn't exist on the tape. I mean, this is why the Supreme Court has created case law when there's prosecutorial misconduct to allow Your Honor to grant a new trial. And this is what it is. I mean, we have proven that. We had the burden, I know this, and based upon everything that was said, based upon the trial transcript, we know this, and based upon the questioning of the jurors that we don't have a clear answer to, I believe that prosecutorial misconduct does in fact exist. When a prosecutor asks questions, makes statements, with reckless disregard, I think that's what happened here. That's the definition, at least according to some of the case law, of what that is. Next, I went through the facts as I read through them as they came in during the course of the trial and are reported by the court reporter into the transcripts. And that's what I wanted to impress upon the court, that the facts, even in the light most favorable to the government, don't rise to the level of convicting Mr. Mullis. When you want to talk about a miscarriage of justice, this is it. This case is it. I mean, Mr. Mullis didn't do this. So it is to sentence Mr. Mullis would be a miscarriage of justice, and we're hoping that the court prevents that today. Thank you, Your Honor.
Thank you, counsel. Let me just address the three issues that Mr. Hamrock argued today. The first issue was prosecutorial misconduct. I will say, with respect to that issue, and perhaps touching on some other issues, today is not a day when I can take evidence and testimony and when I'm going to make factual determinations about certain things. For example, when defense says today that an independent entity of some sort reviewed that tape and determined that none of those things were said, I can't make a finding of that today. There's no evidence of that today. By the same token, there was some reference to what jurors may have said afterwards about whether they heard those same words or did not, or considered them in any way. I'm not making any findings today. There's no testimony to that effect today. And this isn't the right process to make those determinations. I am required to simply review what happened under that argument and make a determination of whether it rises to the level of prosecutorial misconduct. And both parties have talked about recklessness. I don't find that the statements or the questions on cross-examination asked by Attorney Hughes rose to the level of recklessness or to the level of prosecutorial misconduct. There was argument repeatedly made to the jury that they would have to make their own determination. And again, the jury was properly instructed as to statements by attorneys, burden of proof, those types of things. I do not find that any statements made by Attorney Hughes rise to the level of prosecutorial misconduct. The second issue argued by counsel today is ineffective assistance of counsel. And again, today is not a day where I can make factual determinations about discussions that defendant had with his counsel and whether he told counsel certain things or they told him or didn't. Understand, Mr. Hamrock, that you have provided a transcript of your client being under oath in a different proceeding, a probate proceeding, in which he did say, I did not authorize my attorneys to say those things. I understand that. But generally speaking, ineffective assistance is an issue that's typically dealt with on post-conviction relief. In this circumstance, based on the arguments that both parties have made, I do think that that is an issue that will have to be addressed on post-conviction relief. I do not find today, based on the record we have here today, that the defendant was deprived of effective assistance of counsel. The third issue argued today deals with the totality of the evidence, taking all of the evidence that came in and considering it in the light most favorable to the non-moving party, which is the state here, and defendant's argument that considering all of that evidence in the light most favorable to the state, it still was not physically possible for the defendant to have committed this act. Neither party has made any argument that the jury was improperly instructed. So we did have 12 jurors properly instructed on the law after a lengthy trial who unanimously agreed to a finding of guilt. Ms. Hughes recited the law as it pertains to the burden today and what I have to consider, and I think she properly recited the law. I would say I think that I'm actually required, or at least that I should, independently weigh the evidence and consider credibility as it pertains to a motion for new trial. If the verdict is contrary to the weight of the evidence, the defendant is entitled to a new trial. I cannot say that the evidence in this case, or that the verdict is contrary to the weight of the evidence. As to the defendant's motion for new trial and motion in arrest of judgment, I will deny those motions in their entirety. We will go ahead and proceed with sentencing at this time. We have not had, I don't believe, a pre-sentence investigation. Typically, we don't have one for a Class A felony. And I will take argument from counsel to start. Ms. Hughes, do you want to make argument on behalf of the state?
All right, I'm going to push pause because I want to explain a couple of things.
Obviously, Your Honor knows that the defendant was.
Okay, so I understand this comment here, Amelia. Okay, but in order to understand why the judge did what he did, and you too, Miss Allie, you have to understand the steps available to a defendant and to the state after a guilty verdict has been rendered. This specific hearing for this specific day was set for sentencing. And what the defense is attempting to do here is to skip a step, meaning they want to file motions for new trials. They want to file based on ineffective assistance of counsel, based on prosecutorial misconduct. And the judge is saying that a sentencing hearing is not the time nor the place to be arguing this. He is not prepared to hear arguments or testimony or any of or listen to evidence or any of that stuff, and the state is not prepared to counter anything that the defense may raise. So
I have a quick question then. At the beginning of this, when they talk about the motion for a new trial, why did they add it to the? I thought that so this is why I'm asking. I thought the judge said that they purposely put the motion for a new trial in with this hearing.
Yeah, and that didn't make a whole lot of sense to me because he just said that this is not the time or the place for that.
They probably did that because of COVID.
Well, that's what I'm trying to. Can we go back just to the beginning of it, right around that time? Because I want to hear exactly why they say they add that motion in.
Okay.
Why is there not a separate hearing? That should have been a separate hearing. I agree with the judge what the judge is saying now, but I'm almost positive the judge is the one that put the motion for a new trial in with this hearing.
And I don't understand that. The only thing that I can think of is that it may be what Allie or what Shmita has said, which is COVID, which actually I kind of don't know about that one, but I can see that, right?
So then if you're going to add it to this, then why would you not be prepared to hear witnesses or hear any of this? That's why I'm like, I'm confused on why it was even included, knowing that it would not be the correct time. And if you're including it as the judge, why are you not making sure that it is the right time?
Yeah, let's rewind and see what he says. Because I don't know the answer to that. Okay. What the hell? Why is there not sound?
It takes a minute. I don't know why they didn't have the mic on for the whole time.
This matter on September 16,
All right, here we go.
2019. On September 23, 2019, the jury returned a verdict of guilty to the charge of murder in the first degree. The defendant has filed a motion for new trial and motion in arrest of judgment, filed on November 4, 2019, and a second motion on February 28, 2020. The second motion was filed with the court's approval as to timeliness. Filed responses to those motions. The matter is scheduled today for hearing on the defendant's motion for new trial and motion in arrest of judgment. I have read and printed the motion, the state's responses. I will say for the record that all of the pleadings by both parties.
This makes no sense.
That was my thought. That's why I had to go back and listen, because I'm like, I swear he's the one who's saying it's scheduled for today.
Supplement them at this time if they would like. Mr. Hamrock, it is your motion. Do you want to go first?
Yeah, this makes no sense. I mean, I understand why, like, I get why he ruled the way that he did, right? But hold on, let me make sure.
Within discretion, is within the in writing that
4938.
that was the manner in which.
Thank you, Mo.
It was court approved in a matter of
We'll
timeliness.
take argument
So it's
from
like
counsel.
he's only hearing the motion so that they don't hurt Todd Mullis's rights. Because the first motion for a new trial was November 4th, 2019.
Mm-hmm.
That, which actually might be very close to when she was saying that Supreme Court case was, now that I hear the November 4th, but that's neither here nor there. But why? And then he has to file it again in 2020. And the only reason it's approved is because of timeliness. So he's not prepared to hear anything. He's not prepared to actually give two shits about this motion.
No, he's not. Mm-mm. And then on top of it, his answer has to do with procedure. Nothing else. As to why he is dismissing, why he is dismissing the motion. On all of it. He's summarily well, that's not technically summarily, but he's dismissing every single motion. Or not every single motion, every single reason of the motion. Hello, Teresa, are you there?
Yeah, I'm sorry. I have a little person talking to me at the same time.
Oh, okay. Well, little person overrules Jen. I understand.
Only
that.
because he's louder and right next to me.
Well, ask him if if he needs representation. I take on little people as clients. I've gotten him out of lots of trouble.
It's true.
It is true. My record of representing little people is impeccable.
Yeah, I can't even give my kid trouble around Jen. She's like, well, hold up.
She argues on his behalf. I love it.
Every single time. I have several.
Yeah, it was like, I'm hungry. I'm like, literally, we just finished dinner not even an hour ago. Like, what do you mean you're hungry? I'm hungry. I want something to eat. He's like, can you help me out in 5 hours? I'm like, yeah, sure, I'll help you in 5 hours. Then he comes back. He's all, has it been 5 hours yet? I'm like, oh my gosh.
Perhaps he's going through a growth spurt and his metabolism has sped up and he needs the additional calories.
Apparently. All right, so give me just a second. You guys go ahead. I'm just gonna get him settled.
Okay. All right.
Okay.
You do what you gotta do, babe. I just don't understand. I mean, he just I can't. I'm gonna push play because I can't. And then we're gonna talk about what Tony asked because I started that, because that's a good question.
To start, Ms. Hughes, do you want to make argument on behalf of the state?
Yes, sir. Obviously, Your Honor knows that the defendant was convicted of murder in the first degree, which carries a sentence of a mandatory life imprisonment without parole.
They really do,
Judge, you heard
Tony.
the evidence. You know what the defendant was charged with and what he was found guilty of. We would ask you to sentence the defendant accordingly.
Mr. Hamrock, do you want to make argument on behalf of your client?
Well, Judge, in a Class A felony, there's not a lot of argument to be made, so the court would go ahead and impose sentence.
Yes.
Defeated.
The court really doesn't have much discretion in this case other than in one area. That area is death of victim restitution. As the court is aware, that is a mandatory minimum $150,000. This case is such where that would not be justice. This individual came into court at the time of bond hearing and said he had the ability, the cash, to post $1 million against a bond. It is appropriate that this court, at this time, make that $1 million that he has available the death of victim restitution, because that's the only thing I think is going to really hit home with this individual. Yes, he has to go to prison for life, but this trial was about greed and jealousy. The greed had to do with his farm and his money. So to really hit home, Judge, it would be appropriate for that money that he says he had available to go to death of victim restitution. Thank you.
Thank you.
Damn.
Mr. Mullis, you have the right to speak to. You're not required to. Your attorney has spoken on your behalf. This is the only chance you'll get to speak today before I pronounce judgment. Is there anything you would like to say today?
I did not do this. This is supposed to be America where you have a chance of proving your innocence. But you shouldn't have to prove your innocence. Instead of the other way around. I thought it was guilty until, or not, innocent until proven guilty. I feel this is the other way around. And I was a faithful and loving husband and I never did this.
Okay, thank you, sir. Mr. Hamrock, do you have anybody else that would like to speak on behalf of your client?
No, Judge.
Are there any victims that wish to be heard today?
Not live testimony, Your Honor. The state did file a victim impact statement, and we would just ask that Your Honor read that.
Okay. And there is a victim impact statement in the court file. I have read that, and I have conferred with counsel to make sure that they have had the opportunity to see that, and both parties have had the opportunity to see the victim impact statement. I will take that into consideration as if it were offered here live at the sentencing hearing. Defense counsel indicated that the sentence in this case is mandatory. He's right. It is mandatory. There's really no discretion as to the punishment handed down. According to the statute, Mr. Mullis, for the charge of murder in the first degree pursuant to Iowa Code Section 707.2, you are sentenced to life in prison with no opportunity for parole. There will be no fine issued. You'll be required to submit a DNA sample to the state of Iowa. The reasons for my sentence today are primarily the statutory requirement, the fact that there is no discretion. I will also require you to pay a victim restitution to the victim or to the estate of the victim in the amount of $150,000. You will be obligated to pay the court costs associated with this proceeding. You do have the right to appeal from this judgment. Written notice of appeal must be filed within 30 days of today's date. By statute, according to Iowa Code Section 811.1, subsection 2, you cannot be admitted to bail in the event of appeal. Is there anything else the state knows of that we need to cover here today?
Nothing further, Your Honor. Sorry.
Mr. Hamrock, anything else that you need to cover on the record today?
No, Judge.
Okay, we'll stand adjourned and close the record. Thank you, everyone.
That's rough. Because if he didn't do it, he's going to lose his farm and everything trying to defend himself.
Yeah. But he got convicted of murder in the first degree. It's a mandatory life sentence. The judge had nothing to, there was anything he could do, even if he'd wanted to. I don't think he wanted to, but he couldn't have done anything.
So bad he didn't have this lawyer to begin with. He got an expert to go over the 911 call already. That's more than his defense did.
It doesn't. Here's the thing, though. It's very, 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 very difficult to say this is why appeals are very tricky, because a lot of appeals are based on particularly to get a new trial. All right. What happens for that, which is what he has filed, is that they look through the trial, they find all the errors, yada, yada, yada. Right. Then they look at the errors, and they have to look at the errors, and they have to make an argument to the judge who, mind you, was likely over. I don't know how Iowa does it. I don't know if it goes to the original trial attorney or a judge initially, or if it does, if it's a separate one. But most of the time, it's very difficult when there's trial errors to prove that these errors were so significant that a reasonable jury of 12 people would find him not guilty. Those are very, very difficult appeals to mount. This is going to be an incredibly difficult appeal to mount. And even with the 911 call, let me say why it's going to be difficult. Because he's already conceded that one of the jurors said that they didn't really place any emphasis, it didn't factor into their into why they found him guilty. That's going to be difficult. I'm not saying that it's not right. I'm just saying it's going to be difficult. These are very, very difficult. Appeals are very difficult trials are difficult, but appeals are harder. But I do
Right.
think he should get another trial. I do think that the prosecutor saying that there were specific words uttered was not just highly inflammatory, it was reckless, and it was likely prosecutorial misconduct for that, because it wasn't the only thing that was entered into the evidence was the fact that the 911 was called. She played the 911 recording and never said one thing about that at all when the tapes were admitted into evidence, and then waited until he got up on the stand and asked about it.
I think
And
her saying the words is the misconduct.
correct. Her saying it, because she never at any time introduced into evidence on any level that there was something that they could audibly hear him say on that tape, other than the chest compressions and, what he thought had happened, all of those things. She never at any time mentioned any of that, and waited until he got on the stand, played a snippet of it, and then said, "Did you say cheating whore? Did you say go to hell, cheating whore?" Completely inflammatory. And yes, likely borders on prosecutorial misconduct, if you know.
I agree, because she basically told the jury what to hear.
Well, right, but it's not that it's that it's not just that, because here's what the state's going to come back with. Yeah, but he already talked to one of the jurors, and one of the jurors said they didn't even consider the 911 tape.
And I thought he was just saying, like, I know that the state, or he calls it their government, but he's like, I know that they're going to come back and say that at least one of the jurors was interviewed, blah, blah, blah. Like, I thought that he was just kind of preempting what he figured she was going to say.
No, I think he said that one of them was, like as it did actually happen. And then he said, but the problem is, you, Your Honor, were not in there with the jury. I was not in there with the jury. So I think that one of the jurors was asked about the 911 tape. And so
I'm ready for the motion.
yeah, me too. I think that
I
yeah.
haven't watched the motion, so I'm watching with y'all.
All right. Let me give me just a second. I'm very curious.
Thought when Schmida sent me the present, I thought it was what we just watched. I didn't know it was something new.
Mm-hmm.
But it's
Remember, she said I have a surprise for you.
What'd she send you?
The motion.
Oh.
But I didn't watch it.
Because she hadn't watched it yet.
Yeah, I thought she'd just send me what we just watched.
Hold on, let me
Oh, Teresa, if you watch this next case with us, well, everybody in chat too, you're gonna be astounded by the differences. They even have a crime scene reconstructionist.
Wow. Like they're actually doing their jobs.
Okay, but did you see the before we start this, I just want to point out, do you guys see what his new lawyer pointed out as reasons for ineffective assistance of counsel? At any time did he did he argue that it was because the other defense attorney didn't object more?
No.
So not objecting to questions is not, it typically an ineffective assistance, a successful one, is mounted on a situation where there was a conflict of interest. I'll give you an example. So with the West Memphis 3, they raised their ineffective assistance of counsel on the basis that their counsel, their defense attorneys, were paid by HBO Productions, Joe Berlinger, all of that. And that was a conflict of interest, that the money kept them from being the very best advocates for their clients, Damien, Jesse, and Jason, in so much that they were not with their clients every single time HBO Productions, Joe Berlinger came out there to the jails and interviewed them, or during the trial. Sometimes they were in the room, sometimes they were not. And so it put their, when their new lawyers took over for the appeals process, it put their clients at a disadvantage, and there was a conflict of interest there, where their trial lawyers argued, we took that money so we could use the money to pay for expenses during the investigation, so we could be the very best defense attorneys we could be. But those are the types of things that are successful. Like I'll give you an even better example, Brandon Dassey. The fact that Brandon Dassey was allowed to be interviewed by after he was arrested without his attorney present. His attorney gave them permission to interview. Remember, that's when the picture got drawn and all that stuff. That is an excellent and effective assistance of counsel claim. That's all I wanted to point out. Okay, let's play it.
So this was a month ago,
Yes.
this hearing.
Yes.
Not even, right? How long? When was it? The 13th?
No.
Or,
Yeah, 12th or 13th. Something like
and how
that.
long do they have to come back with a decision is what I want to know.
We'll find out
30
because
days, I
they'll talk
thought.
about it. No, they have 30 days to file after the thing. Yeah, the judge has a minute for an answer. They got a minute. They got a while.
All right. Hear ye, the Honorable Presiding Judge Schumacher, Associate Judge Bading, and Senior Judge Gamble, the Iowa Court of Appeals.
Oh my. They got a panel. Fancy Iowa.
Good afternoon and welcome to the Iowa Court of Appeals. We are here today for 2 oral arguments. The first case set for today is State of
Don't
Iowa
giggle,
versus
Teresa.
Todd Michael Mullis, file 20-1173. The appellant, Mr. Mullis, appears through counsel Aaron Hamrock. The State of Iowa is present through Assistant Attorney General Bridget Chambers. So counsel, when you're ready to proceed.
Thank you, Your Honor. May I please the court? This case is a sufficiency of the evidence case, and one of the main reasons that we've asked for a bit of time to be able to stand here and speak to the judges is because it's very important. And on page 12 of our brief, we've put an aerial photo in that was exhibit number 111 at the trial stage. But in this particular case, and I've had an opportunity to visit the property and to understand the sufficiency of the evidence argument, in looking at page 12 and the aerial photo there, it's important to note that on the morning of November 10, 2018, Todd Mullis and his son were in another area planning to do some chisel plowing and other farming stuff. They came back to the property because they weren't allowed to do it due to the weather. Came back to the property, had some breakfast, and they raise a lot of hogs, and so they needed to get these hog barns ready for the hogs to come in and be able to be raised through the winter. So Mr. Mullis and his son were out in what's marked on here as 10 and 11, which would be the North Hog Barn. And these hog barns themselves are about 100 yards or a football field in length. And at the very west of the hog barn, you can see a little white chute that comes out. That is a chute where semi-trailers can back up to when they're going to load or unload these hogs. And that chute stands about 6 feet tall or so. The other entrance into the barn is at the southwest corner. There's a door that leads into the office, and we've talked about the office and where the spigot is at, where the son, Tristan, went to get a couple of drinks of water while he and his father were working in the barn that morning. The only other exit from the barn would be at the very east end of the barn, about halfway between the 2 corners, which is a big sliding door to get out, and that would be the other exit. In this particular case, the evidence that came in at trial was that Tristan, his father, and Amy Mullis, the mother, were all working in the barn for a period of time. Now, Amy had a medical procedure 3 or 4 days prior to this. Amy was not feeling well. Tristan and his father indicated to Amy, you should go back inside, but if you could, over where it says red shed, there was a pet carrier located in there. They wanted the pet carrier because they had to do some work after they were done in the barn over in the red and white shop, which is clearly marked on the photo as well. In that shop were a bunch of cats that ran around in there. They didn't want to run them over with the heavy machinery that they were going to be moving around to do the work that they needed, so they requested the pet carrier. So in this case, we know that Amy leaves. She's requested to go get that out of the red shed. Tristan continues to clean light fixtures that are in this hog barn, and his father continues to put in the nipples for feeding of these hogs when they get there. They're together, we know, in this hog barn for about an hour and a half total, according to the evidence. We know at a period of time after Miss Mullis leaves is when Tristan goes to get a drink of water. He gets that drink in the office where there's a spigot and a small hose, turns it on, drinks some water, turns it off, goes back to work. They were working right around the corner from the office there towards the west end of the barn. Now, we don't have an exact amount of time to get 2 drinks of water, but common sense, I think we know that that would be no more than a couple of minutes to get those drinks of water. So what would have had to have happened here, because Tristan never saw his father, the testimony was, never saw his father leave this hog barn, what would have had to have happened is Mr. Mullis would have had to have sprinted down almost the entire length of the hog barn to the east, exit through the doors down at the east end of the barn, go about 20 yards south to the area between the north and south hog barn, sprint back up that area, which would be another 100 yards. And then there's a period of feet over to where the red shed is. Okay, he would have had to have located Miss Mullis there, and somehow he would have had to have known she was still there and didn't already retrieve the pet carrier and go on inside, but he would have had to have known that she was there, go over there, commit the assault, and then run all the way back and get back into position, doing the work that he's done, not being out of breath, disheveled, or anything else, prior to his son getting that drink of water, walking back around the corner and starting his work again. You know, they were the only 2 people in this barn. So it's not like it was a crowded barn and Mr. Mullis could have gotten lost somehow, or he could have taken his, they were the only 2 people working together after Miss Mullis left in this barn on November 10, 2018.
The evidence that the family were the only people present at the farm that day?
That was the evidence, yes.
Aren't in a sufficiency of the evidence challenge, don't we need to view the evidence in the light most favorable to the state? So how do you square that with how you've presented the facts on appeal?
Well, we believe that this was an accident. We don't believe that this was a murder. I understand that there were some of that had been conceded previously at the trial level, but that, I mean, realistically, that's how I look at the facts and looking at the sufficiency of the evidence. It would be physically impossible for Mr. Mullis to have traveled the only way he could have gone to not be seen. And by the way, the evidence was while they were in the barn, they would wear a special boot covering their shoes so they wouldn't track disease from outside inside, which could get the hogs, which are expensive, get them sick and cause them additional money or death. So, you know, that's on top of everything else that he has these special boots on that he would have taken off. So
your argument that this was an accident with the autopsy reports that indicated there were more than one set of entry wounds into the victim in this case.
That could be explained in that if Miss Mullis did slip, fall, got dizzy, you know, due to her medical procedure, there were some questions about, you know, Miss Mullis, or some testimony about Miss Mullis not feeling well and being dizzy. If she slipped and fell and she impaled herself with this corn rake or corn fork, a person's first inclination, most of the time, I mean, if you get a splinter into your hand or you cut your arm or your hand with, let's say, a piece of glass, your inclination is to remove that. Very well, it could have been her inclination to remove, reach back and pull that out, get it out of her. Did she slip or fall again? Very well could have. Did she possibly pass out? Could have. We don't know the answers to that, but that is certainly an explanation as to you know, there being the 6 puncture wounds.
Emrock, your client did not claim that it was an accident at trial and testified that somebody had to have done this, just wasn't him. What is the direct evidence or even circumstantial evidence that anyone besides Mr. Mullis committed this crime?
And that's assuming that it was, Your Honor, that it was a crime and not an accident.
Testified under oath that it was not an accident.
You know, we don't have any evidence that anybody else was on the property that day. I have not heard anything come forward. You know, did that if this was a crime, did that happen? It certainly could have happened, and they didn't see anybody. They were in the hog barn working that day.
But what evidence is there that anyone else was there? Was there any evidence, any physical evidence, any witness testimony, anything?
Circumstantial, direct evidence that another person or people were there besides the family.
Thank you.
Somebody wasn't there. I just don't have any evidence.
In terms of weighing the evidence, there's a weight of the evidence claim in this file.
You know, but in looking at what would have had to have happened, the physical portion of this, it would be simply impossible. Thank you.
We'll have an additional 5 minutes on rebuttal. Ms. Chambers, when you're ready.
Oh, Ms. Chambers came with a new do.
May it please the court. This is not a closed case. The evidence of Todd Mullis' guilt is simply overwhelming. Only Todd Mullis and his son Tristan knew that Amy Mullis was going to that red shed.
That's not the same attorney.
Only Todd.
Yeah, that's
asked her
a
to go
different
there.
lady.
I just
Only
realized
Todd
that when
placed the
she
murder weapon
spoke.
in that shed within a month of that time. Only Todd had multiple strong motives to kill Amy. And only Todd, while purportedly giving her CPR to save her life, whispered, "Cheating whore," and "Go to hell, cheating whore." The defense has suggested a number of things that certainly could have happened. This is a sufficiency review. This court cannot reverse on speculation of things that could have happened. The court must look at the evidence in the light most favorable to the state and determine whether the jury could reasonably have reached a guilty verdict. This record absolutely supports the jury's guilty verdict. First, let's look at what did not happen. There's no evidence of a break-in. There's no evidence of a burglary. There's no evidence of a sexual assault. No other person was identified as being at the farm other than Todd, Amy, Tristan, and the two younger children who were in the house. The only people on the farm who could have committed this crime is Todd. The two youngest children would have been elementary school age at the time of the crime. Clearly, they did not plunge a cord and fork into their mother's back. Tristan was in 7th grade and 13 at the time of the crime. And Todd Mullis, if you look at the photographic and video evidence, is a strapping adult. All of the evidence points to only Todd as the murderer in this case. It was Todd who sent Amy to the shed. He sent her to the shed to get the pet carrier, knowing that it was well inside the shed in a place that would be out of sight from anyone outside the shed. He also knew that it weighed 15 to 18 pounds and that Amy's doctor had advised her not to carry more than 10 pounds. Yet, after she was dizzy in the hog barn, he sent her out to get the pet carrier.
How do you respond to the defendant's argument that it was physically impossible for him to have had time to get from the hog barn to the red shed to commit the murder?
There are two assumptions underlying that conclusion on the part of the defense that are not justified here. So first of all, the defense seems to believe that just because Tristan did not see his father leave the hog barn, he must have gone out the east doors and run all the way to the red shed, which, by the way, is about 100, would be at the most, not taking any shortcuts, would be about 150 yards. Todd is a young man who appears at least to be in good physical condition. That would not be a marathon for him. But it also assumes that he did that. So Todd and Tristan were working in the same immense building, each doing their individual jobs. Tristan's job was cleaning the light fixture, so it involved him looking up towards the ceiling. He was also 13. He was not keeping track of where his father was every second of that morning. For them, this was just a normal morning.
Physical condition.
Tristan had no reason to have heightened awareness of where his father was. His father was putting up the nipple bars. If you look at the photographic exhibits, that you can see that the hog barn is divided up into pens, and some of those have solid panels. So it would be very easy for Todd to have been someplace in that building where Tristan couldn't actually lay eyes on him. And yet Tristan logically would have thought they were both there together.
Could you respond to Mr. Mullis's argument regarding the number of puncture wounds in the victim's back and whether that could be an accident if she fell once or twice on that particular piece of equipment?
Is it impossible? Maybe not, but this is a sufficiency review. And the odds, the jury could extremely reasonably have determined that Amy Mullis did not fall on her back twice that morning. that she fell once and somehow was, and those, let me point out too, that those wounds were not superficial scratches so that she could have just reached back and moved that fork out of the way. They were deep, penetrating wounds. The odds that she was able to pull the fork out of her own back and then somehow manage to fall on it again really defies credulity, and the jury acted reasonably in not following that path. I would also point out, as the court has recognized, that was not the theory in the trial court. And on sufficiency review, the defense does not get to change their theory. Todd Mullis testified that he thought someone inflicted that wound, and that's the jury. That's the theory that the jury was evaluating.
Chambers, as I understand the autopsy, there was defensive wounds on the left hand of the victim. Was there any evidence that Mr. Mullis had been in a struggle, like any evidence of disheveled hair, wounds to his face or hands, torn clothing, blood on his clothing, blood on his boots, anything like that?
No, so I would first say that there's evidence. I sort of undercut the theory that maybe that Amy fell on the corn fork twice, but no, there was not evidence of blood or wounds to Todd Mullis. But remember that he would have, by the time the police saw him, or by the time anyone other than Tristan saw him, he would have already carried Amy's body to the truck. He would have helped get Amy's body back out of the truck where the deputy met them and they performed CPR. So if there had been blood on Todd Mullis, that wouldn't have drawn any surprise. There was no evidence of bruising or wounds or scratches, but again, not horribly surprising. The fact that Amy had scrapes on her doesn't mean she struck Todd in some place where it would cause injuries on him. It was a cold day. They were wearing heavy clothes. Presumably he was behind her at least part of the time. Todd had extremely strong motives to kill Amy Mullis. He knew that his wife was having an affair. The affair began in May or June. By July, Todd Mullis was sufficiently worked up that he confronted Jerry Frasher and Jerry Frasher's wife about what he believed was an affair. Todd Mullis was angry. Todd Mullis also had a motive to kill Amy based on the fact that it would be a financial disaster for him. Amy Mullis testified, or told a friend, that her share of the family farm trust was about $2 million. And if they divorced, Amy would get that $2,000. Todd had also told people over the years, once right after Amy's first affair, he told Eileen Fuller that he was working things out with Amy because he wasn't about to lose the farm he'd worked for his whole life. In August, before Amy was murdered, Todd told their mutual friend Terry Stainer that who was really kind of trying to gently encourage him to just divorce Amy. Things weren't good. They all knew it. Maybe he should just reconsider whether he wanted to stay in that marriage. And he told her that, and I quote, "I've worked for this farm since I was 11 and I will not give it up." Todd was angry. Todd's third motive regards his kids. He had not been an attentive father, the record shows. He had not been close to his kids. Shortly before Amy's murder, he had tried to kind of move closer to Tristan and had apparently made some success in doing that. But he wasn't the father going to the dance recitals. He wasn't the father going to the gymnastics meets. He was not the father cooking, cleaning, and taking care of the kids. He was not going to get custody of those kids, and he knew it. And
most fathers that work all the time.
All of those problems went away. There's also abundant evidence that Todd had ongoing concerns about unfaithfulness. On Christmas of 2017, Todd was researching cheating women. Amy's friends testified that he kept her on a very short leash, and she essentially had to check in and out when she went places. By May of 2018, Todd was searching online for evidence about other cultures and whether they killed adulterers. He looked at a newspaper article about a husband who killed his wife and what the sentence was. He looked at multiple ways of killing someone and how does one survive in different situations, all suggesting that he was considering different methods of killing his wife. In the short time I have left, I just want to talk briefly about Todd's reaction to Amy's death and to being told that she was murdered. He showed virtually no interest in finding out what happened to Amy. There were video cameras on the farm, one of which was pointed at the red farm. He didn't even mention that to law enforcement. He didn't check them until the day after Amy died when other family members suggested it. When he saw that the camera had been knocked out of the window, not knowing when that happened, he just went, I guess must have been out, doesn't show anything. He never checked. Those are not the actions of a husband who wants to know how his wife died. And when officers told him that she had been murdered, there was no outrage, there was no shock, there was no crying, there was no emotion. He simply said, there's no evidence. This is not a man who was grieving his wife who died of an accidental injury.
Shut up, lady. I don't like you.
Hamrock, rebuttal when you're ready.
Thank you, Your Honors. With respect to, the state talked about motive and talked about some computer searches that the state wants everyone to believe that Todd Mullis completed. Well, first of all, a computer search for over a year ago from the time of this accident, I mean, is stale evidence at best. Let alone trying to say that, well, because of this computer search, and we believe that Todd is the one that did it, when the evidence was that lots of people had access to this iPad. The kids used it, Amy used it, his brother Mike used it, other family members may have used it. It doesn't necessarily mean that Todd was the one doing searches. So they also talk about, for instance, Todd and Amy's daughter was doing some research because she was getting her hunting license and had to know, I don't have a hunting license, so I don't know all the details of the test, but was studying for the test. The state also talks about, and the question was posed, there were not, the 6 wounds were not all on the back. As I recall, the autopsy report, I believe 4 wounds were towards the back side, and then there are 2 wounds that I believe talked about the right side of Amy's body, not on the back. That very well could be consistent with somebody who did pull the rake out, panic, that's what they wanted to do. They wanted to get it out. And if she slipped, she fell, passed out, whatever, could easily explain why there were 2 puncture marks on the right side, not on the back.
Witness acknowledged that was a possibility, specifically the medical examiner?
I don't recall if the medical examiner seems to me may have been questioned about it, and we'd have to refer to the transcript to be positive, but may have been questioned about it. And one of those, well, I suppose it could be possible kind of answers, but I can't stand here and point you to the exact line that was set at.
Respond to the state's error preservation argument regarding the sufficiency of the evidence issue. Do you believe that you've preserved error beyond just the identity element?
Your Honor, I do believe that error was preserved. We put in our reply brief, we specifically outlined it where trial counsel, in talking about it at the trial court level, made it very clear in arguments that this was sufficiency of the evidence as to intent and as to whether or not Mr. Mullis was the person that committed the crime. So I believe that it was clear. And, there's also the State versus Foley case decided by this court back in 2017, which talks about essentially that, and under the circumstances of that case, the record clearly revealed the trial court and counsel understood the grounds for the motion of judgment of acquittal targeted the insufficiency of the evidence to support the first element of assault due to limited physical evidence and the hearsay nature of the testimony. So I believe that error has been preserved in this case.
So could you respond to the state's comments about your client's statements on the 911 call when he's performing CPR?
My response to that is I can't believe that the prosecutor actually kept saying that and was allowed to say that. There's no evidence of that. You can't hear any of that. That was very disturbing because clearly Mr. Mullis did not make any of those statements and should not be considered as motive in this case. And we brought that up at the trial court level when we were arguing at the sentencing phase of this, that, our thoughts as to whether that was misconduct or not. Any other questions? All right. Thank you, Your Honors.
Consider case 20-1173 submitted, and we will issue a written decision in due course. Thank you, counsel, for your arguments today.
Okay, Mo, I totally agree. And if you hadn't said it, I would have said it myself.
So
I didn't like her, and she got things wrong.
Yes, she did.
First she said 2 million, then she said 2,000.
Yeah, she's
but
gonna
that
get
wasn't even as important. Yeah, I was like, that ain't worth killing somebody over.
Well, she's lucky that the defense right now is what has to be the ones that has to prove their case, because she would have lost in trial court.
Yeah, that was a bad move, not knowing the difference between 2 million and 2,000. But
and bringing up the 911 call.
Yeah, I'm surprised they let that slide again.
I was thinking about that.
I don't know why she brought it up. Maybe she didn't know what he argued in the sentencing.
Well, she had to have known, but remembering it, I don't know. But it wasn't, there was no ruling on that. So technically she would be allowed to bring that up.
Alex 79, yeah, she probably should.
That's
I
why
wonder why he didn't say he had an expert go over that.
I wondered the same thing.
because I don't think that that was the purpose of this. So what he was basing the motion for a new trial on, and what they were listening to today, or in this trial or this hearing, were the weight of the evidence. So I'm gonna have to think about this one for a second, how to explain it.
Well, she didn't say how long we had to wait.
No, she didn't. She said and do something or whatever. There's a time frame. I just don't know what it is. I'm not a lawyer, so I don't know all these things off like the top of my head. But I think the reason he didn't bring up that they had an expert witness is because I don't think this is the time where they would hear an actual innocence claim. Which I think it's got to be what I mean. I know he's going for ineffective assistance of counsel, but that wasn't. I mean, that's one of the things that they were. But I'm wondering if this prosecutorial misconduct is going to be at a separate hearing. Meaning, I wonder if he has to file a different motion for prosecutorial misconduct and submit all of his evidence of prosecutorial misconduct, which seems to center around this 911 call, and that's a separate issue.
Maybe we should look at the motions filed.
How do we, hold on. Let me look.
He asked, though, he should have shared his expert's finding on. I agree. I think so, too. Talk about anxiety. Yeah.
Yeah, that's what I would have said. And they would have been like, oh, really? So I don't know. I hope he gets a new trial, though. And about them asking about what the medical examiner testified to, I was like, nothing. She was no help at all.
Oh yeah. Did the guy doctor or her say anything about it? It could have been an accident. Did the defense even ask that question?
I don't think they were actually even asked.
That's probably where he's like, "Son of a bitch, here's your ineffective counsel." You know,
right? Exactly.
I was thinking that when we were listening to the sentencing and they were going over the motion, that Todd's saying that his attorney, and I know that I remember Todd being all about the fact that it was an accident, and I remember like the weird way he went to answer that one question and stopped himself, but they did ask him about it being a murder, and he did say that apparently that's what it is. Like he did concede to that while under oath.
Yes, he did.
Oh, that beyond the story, that was a great point. That was one thing I thought of too. She was like, obviously the other two were of adolescents, and so they clearly didn't do it. And I'm like, have you not heard of Aiden Fucci? Like, what you talking about?
Right, 13 years old. He was old enough to raise a pitchfork. And I'm glad they brought up the 150 yards because that's exactly what we discussed too.
Yeah, but
she said he was a strapping young man.
He was overweight.
Okay.
He did not run 150 yards, commit a murder, and run 150 yards back without Tristan being like, "Where's Dad?
What the hell's wrong with you, Dad? Why can't you breathe?"
Right. And I think it's very telling that he had no wounds on him at all.
I can't.
Yeah, I think the questions that these judges ask is very interesting in what their thought process is.
Yeah, they're very smart.
Smarter than the judge at the trial.
Right. I like the two women better than the man, though.
It's all news. I can't.
Google and be on StreamYard on my
Yeah,
phone. So
I know, and
that'll piss me off.
for whatever reason, I guess I just don't remember how to freaking Google. What's the county he was in?
He was tried in Dubuque.
All right. Thank you.
Dubuque.
Dubuque.
What do we call the devil?
It's not a devil. It's a demon.
Or,
it's a Dybbuk.
The demon.
Dybbuk.
Yeah. That's why I was laughing.
They should bring in a Vikings player for expert witness on running. The Vikings suck. It would probably agree it's impossible.
All right.
Oh, that's just funny.
Well, there was a motion March 6th. Wait, what? I don't even remember what we're looking up.
I got it.
I have the worst memory. I have ADD, and I just was like, "Whoa, where am I?"
How did I Google this? What am I doing here?
Well, I found a motion he filed in March, but then I was like, "Is that even
2020? 2021?
March 6, 2020.
Huh.
Well, I'm wondering if that's the same one.
Where'd you find that?
Hold on, I'll share it to you. I typed
I'm wondering
in
if that's the one that they were
Todd Mullis
saying.
motions.
What motion? What's the motion for? New trial?
Motion for a new trial.
Yeah, I think that's the one that they were talking about in the sentencing when they were talking about the motion, that they allowed it to be heard then because of the timeliness.
Look, number 2 for the motion, Deputy Travis Hemestath was not a qualified expert. I believe that juror number 4 said that repeatedly. And Deputy Travis Hemestath provided improper hearsay testimony.
Who did? Who provided hearsay?
The expert Travis.
No.
Defendant's attorneys did not go with the accident defense against his wishes. The defendant's attorney did not inform him of his right to testify. Oh, wow.
They did not inform him of his right to testify?
Of his right not to testify.
Not to testify.
The judge asks, though. You know how usually the judge will say,
Yeah.
Interesting. And number 6, the weight of the evidence was contrary to the verdict.
Oh, you're looking at news. Okay. I was actually looking for the whole.
It should be under the court doc.
I found it.
The cat's knocked over the cameras. Well, they did show a pattern of the cameras not working. It would be weird if they worked all the time and then on November 10th stopped working and then started working on November 11th. They did show a pattern where the cameras were off, on, off, on.
I think that's interesting that they didn't inform him of his right not to testify.
I don't like that they don't let you read it. It tells you what's going on, but it won't let you read it. It won't let you read what's actually been filed.
If you go under filing, will it? Because you can go under like the different subcategories.
All right, hold on.
And I didn't even realize that. I didn't hear that part. But if the defendant does testify, does the judge still ask Well, no, we wouldn't have heard it because it was out of jury. So never mind. Because this case didn't play anything that was the jury didn't hear. Ezra's case plays everything.
Mm.
So I don't know how we want to do that.
There's no, I mean, whatever they play, they play. There's nothing we can do about that.
Well, you can stop it, but.
Yeah, see, no, it doesn't, there's no.
Alice 79. Alice does do that. I can see Alice knocking some camera equipment over.
Yeah, but I would notice it, not 27
All right, I went and
years
requested
later.
some free Todd Mullis Facebook groups.
I did too. As soon as Recliner Detective
try
said that, I
this.
went and requested to join.
I'm probably already in them.
I know.
What? No.
Well, you wouldn't necessarily notice if you owned a whole farm what Alice was up to at all times.
I probably wouldn't let her roam the whole farm, but it's not what I'm saying no to. I can't find these right now. I don't know what, my brain is just not working today.
The dingo ate my camera.
All right, well, we can look for him.
Yeah, I'll find him.
So this is totally off topic, but I have to say it because it's perfect for this occasion. I got a notification that a tweet came through from somebody I follow, and I gotta read to you what it said because the notification came through and I was like, what the hell?
Right.
So it said, psych ward has given Jen brand new socks.
What?
I was like, why the hell is this person tweeting about Jen
and
socks
in the psych ward?
What is this?
What was it?
I really don't even know yet exactly what it is, but it's so then I open it. It says that says psych ward has given Jen brand new socks, increased her nicotine milligrams, and is thinking about letting her make 2 calls per week.
Calls.
Like,
I'm
okay.
up to 2 calls. Look how fancy I am.
I was like, why is the psych ward giving Jen new socks? And why is this dude tweeting about it?
And increasing my nicotine and phone calls.
I didn't know that until I opened it though, but I still don't know what it's in regards to.
That is so weird.
I know, so I was like, I had to take a screenshot of it because I'm like, what? That
is so weird.
The psych ward gave Jen Terry Hobbs' book.
Yeah.
I'm
excited for that. I've been reading it. I was thinking about when you guys were like that, when Mo, when you didn't understand why she brought up and Shmita, you didn't either, right? When she brought up custody of the kids. Okay. So, but I got why she did it. It's not that I agree with her. I just understood it. She's bringing it. So when they were,
yes. Okay.
Yeah. So the reason that she was bringing that up is because Todd's whole deal, their motive, right, a theory, was that Todd was motivated solely by money, okay? And that if they were to divorce, not only would he lose half of his farm, right, but he wouldn't get custody of the children and therefore would have to pay child support. So he would be losing money at the same time as paying money. And that's why they brought that into it, because he was motivated by money.
Okay, I want to call bullshit on the fact that lady says, and it was presented that he was not a good dad.
Yeah, that's what I had a problem with. Not that she said it. I had a problem with her saying that he wasn't a good dad.
Yeah, like why? Like where was that presented? Because I don't remember that in any of the
Patricia said it. Patricia said it. She said that, and so did Terry. They both.
I thought Terry said he was super dad.
Yeah.
No, she said.
Who the hell's Patricia?
That was the one of the last friends that was on the stand. Terry said that Amy told her that all of the sudden Todd had become this super dad. Now he wanted to be involved, but he only wanted to be involved with Tristan. That's what she said.
It's still called bullshit.
I'm just telling
Me
you what
too.
she said. That's what they're basing that argument on. I'm not agreeing with it. I'm just telling you what it's based
Yeah.
on.
But I don't believe that was made clear at trial that he was a bad dad. And he's talking about how he had his daughter doing this stuff, his son was doing that stuff.
Yeah, that's the whole reason he was okay with the text to Jerry, because he thought the kids were going to be able to show pigs and.
Yeah, but who was going to be taking the kids to show those pigs?
Well, I still
Not
don't
Todd.
think that makes him a bad
I'm
dad.
not saying it makes him a bad dad, but when it comes to stuff like this is the stuff that they present and as evidence of him being a bad dad. I'm not telling you he was. I'm just telling you their argument.
Oh.
That's what their argument is. I don't know what kind of dad Todd Mullis was, to be honest with you. Hey, Melissa Jade. I think he was, if I had to take a guess based on all the things that were laid out, I would say he was a regular dad. I would say he did dad things, that the mom took care of the details as it happens in so many homes. That's pretty typical. I think it was a typical family situation. I don't think it was anything like super special or remarkable.
Yeah, and it seemed to me like him and Tristan were buddies.
Yeah, when he got older, and that happens.
Victim impact statements that the judge got and gave to both. I would like to hear those. Why didn't we get to hear those at sentencing? Those should have been read.
Well, I don't know either, because they should have been read, but for what they didn't want to make an in-person appearance, obviously, because they said that. But I don't know why.
They may have asked for it not to be read on camera.
Oh, that could have been too. That they wanted it kept private. But I feel like the arguments that the defense attorney made, the questions after he was being asked about certain questions, he knew that he had the burden in this situation. And although you cannot prepare for every conceivable question, okay, you should be prepared for questions relative to your overall argument. And he would have been more effective had he said, well, we've tested the fingernail clippings and there is DNA underneath them, and the DNA doesn't come back to Todd Mullis.
Oh, yeah.
He could have brought up the
Could
fingernail.
He could have done that at this appeals if he was going with the weight of the evidence not being, not justifying the verdict. I mean, because at that point in the trial, it would have been on the state to be able to do that. And so I'm just trying to think of, would he be able to present that type of evidence now?
I'm not sure, because this isn't a process. I'm not used to Iowa's process. This is the first, I've covered and looked into other appeals and other cases. This is just the first time I'm coming across Iowa, and I'm not exactly familiar with how they do it, but I would think that.
Well, what would have happened if they did present it and there was no DNA under there because it was an accident?
Well, yeah, true.
Well, that was their original argument to begin with, that it was an accident. And so would it have been
better to say there was no DNA under there? I mean, like there was, or I don't even know if I'm not overly familiar with the appeals.
Me neither. And I'm wondering why he didn't just bring up the fact that the state believed that she and the medical examiner testified to the fact that Amy had defensive wounds on her hands, and yet they never tested the fingernail clippings. He didn't bring up them at all.
And then did you hear this prosecutor? She says, well, her back was to him.
Yeah.
I'm like, wait a minute. You just are talking about once again, you're doing the same shit the other prosecutor did. You're saying that there's defensive wounds on her hands, but her back was to him.
And then she quickly slipped in most of the time.
Yeah.
That was slick. My problem with all of this is that because I'm just not, this is a difficult situation or for me to explain because I'm honestly just not familiar with the way that Iowa works as far as how their appeals process goes. I've never seen an appeals process where there's a panel of judges at that level, right? In the initial, although I like it because I think that, it's rather than you having, I don't know, I think different people think different ways. And so I think you don't have to worry about you just getting one judge that's overly critical and doesn't typically place value on new trials or stuff like that, because there's some, it is the way it is. I thought that
Right.
I think that's interesting.
Yeah, because I think the women were more leaning towards him and the guy was more leaning towards not. Just by their questions, but that doesn't really mean anything.
I actually thought the opposite.
Did you?
I didn't think, well, first of all, I'm not going to say that I thought that they were leaning one way or another. But what I will say is that I thought that the female judges' questions, their follow-up questions, were far more harsh and compelling than the judge, the male judge. They asked deeper probative questions than the male judge did.
Right. Well, that's what I meant. If I felt like they were more interested in.
Yeah, but they were. If you're going to say that they were more interested, I don't. What do you mean? I think they were all interested. I think that they were harsher, meaning likely they were less. They probably are the ones that are not going to give him a new trial because of the questions. They were harsher. Is what I'm trying to say. Yeah. Just because what they asked was how do you reconcile the fact that the medical examiner testified that it wasn't an accident, it couldn't have been an accident. Those were hard questions for him to have answered that he wasn't prepared to answer.
Yeah, he should have known that.
That's what I'm trying to say. He wasn't ready to. He should have been able to answer that, and he should have been more prepared to. I will say this: the state argued a lot more emotion and less actual facts, and that's true. The truth, in my opinion, is the way that's what they were really working off of. That he was angry about an affair, that he was not going to give up his farm, that he was not going to give up his money, that he was not going to pay child support. Very emotional arguments versus, and the truth is, would it have been, okay. The reason they keep going back to this whole running situation is, yes, Todd was a trouble. This is true. But he wasn't a smoker and he didn't have injury, meaning he didn't have old knee injuries. He wasn't incapable of running. The run would not have damaged him. He worked on a farm. So you'd be surprised at how quickly chubby people can move. They can actually be quite good at cardio, which is what that would have been.
Yeah, but that's a long way that's a whole football and a half to run, fight with her, stab her twice, and then run a football and a field half back.
But that is, and I will say this, the state made an excellent point. That is assuming that Tristan is 100% accurate and that is exactly how long his dad was gone for. That's a lot of presumption. The truth of the matter is she made an excellent point that Tristan was working and they were not working side by side. Tristan was doing one thing, Todd was doing another thing. I mean, she did make an excellent point for that. I do still think that he should get a new trial based on the 911 call, period. That was highly inflammatory and it shouldn't have been allowed. He can still run. And we're saying, and that's the thing, we're assuming that he had to run. He may not have had to run. There was 2 hours between the last email he sent and the time that he called 911. I'm pretty sure he's capable of walking 150 yards in 2 hours.
200 pounds is not a lot for 6 foot man. Anyway.
Well, yeah, he was 205 pounds technically, according to his driver's license. I believe that's what I believe that's.
I mean, it's not like he was overweight. That's
correct.
Not a lot for 6 feet.
Correct. He wasn't auditioning to be a contestant on My 600-Pound Life. It wasn't sedentary. He could have done it if he wanted to. But again, I think this is part of the issue, though, with the state. They made a good, it was a good argument. Okay. Is it impossible? No, it's not impossible because there were those factors. And we all are assuming that there's a big window of opportunity. For all we know for certain is that at 10:13, she responded to an email from Jerry Frazier. So at least at the very latest, right, she was alive then. And there was nothing after that.
What was it? 10:14, 10:12, she sends the email. 10:14, he responds. And then 12:01 is the 911 call.
Right. So what is that? Almost, just shy of a couple of hours. That's a long time. You can do a lot of things in 2 hours if you're properly motivated. So that part isn't a compelling argument to me. What would be a much more compelling argument for in order for him to get a new trial, remember, the burden is not on the state this time around. Well, she read the first email because she responded. The last email she sent was at 10. What did you say, Teresa? 10:13 or something? 10.
She sends the email at 10:12 that says that guess what I'm doing? I'm working with the lights or whatever, blah, blah, blah. At 10:14, he responds, nice.
Right. And there was no response after that. And we don't even know if she read that one at 10:14, right? So we just know 10:12 for sure. We know for sure at 10:12 she was typing.
Correct.
That's all we know. And we don't
know where he was when that happened. We don't know if that was in the barn. We don't know. That's one of the things we wanted to listen to in Tristan's was to see if he actually says a time, because I don't remember him saying a time one way or the other.
Yes, we wanted to listen for him to say something about a time, and we wanted to hear how he said his mother was laying, if he said anything at all.
He did say they went out to the barn around 9:30 and were there for about an hour.
Which then lines up with that she would have left and she would have been doing that message on the way to the Red Barn or in the Red Barn was what we had thought. And no response was because she was impaled at that time.
If that's when she was impaled, because you have to think about there was a window of opportunity that we can't dismiss. The truth is, and this is what the state is looking at, and this is what these judges that are going to decide whether or not he gets a new trial. There is a little less than 2 hours for him to have done what he needed to do. I promise you they're not going to take where Tristan was. It's not going to weigh that heavy. They're going to be reasonable and think very dry and very logically exactly the way that I'm laying it out and saying it is entirely conceivable. It is entirely possible that Tristan isn't lying. That's not what they're going to think. They're going to think that it's impossible for him to have known where his dad was unless they were working on a project that required both of them to be right there together. And they weren't.
I agree with that.
And they weren't. And so there was time for him to have done what he did. The argument about the sweatiness and all this, that, and the third is not going to really, it's not all that compelling.
My issue still is during the actual trial, you're erring on the side that the defendant is innocent because you'd rather set free a guilty man than lock up an innocent one.
Correct.
And so during the trial, why are they not paying attention to the fact that he doesn't have any of those things, that Tristan was telling the truth? You see what I mean? Like, I see what you're saying on the appeal side, because they're going to look at it differently, because they have to look at it now that the defense has to prove X, Y, Z with these motions, which I still think is bullshit, because the defense never actually was able. The guy can't answer the question of, hey, did the medical examiner say it could be an accident? Because dumbfuck's attorney over here never asked.
I don't think he
Right.
did ask, to be quite honest with
I
you.
don't think he did either.
Well, I'm writing
No,
that
because
down.
he was saying it was a murder. He wasn't going to ask if it was an accident because he started his opening saying it was a murder.
I know,
Right.
but I
That's
just want to make sure, but I'm writing it down just to make sure that we, cover all the bases, like his lawyer should have did. That's not even the right way to say it. Like his lawyer should have done.
Now, when they decide an appeal, do they get the whole trial and they go over it all, or do they just go by what was read there?
No, if you get a new trial, you get a new trial. Everything goes back.
No, the judge is deciding right now if he gets a new trial. Do
Right.
they get to go over the whole transcript, or they just go by what was just said?
Oh,
seems like
when
they
they're
already had the
making
whole
their
transcript.
decision, when they're making their decision,
Yeah.
they look at what was filed, and they look at case law, and decide from there. So
So
whatever.
they don't look through the whole thing.
No.
Okay, she said they're gonna get the decision in due course.
Yeah, due course.
Okay, so is that like a fortnight? I mean, like, what is that? Like, is that like is due course just whatever the hell they want to? Or does due course actually have like a timestamp on it like a fortnight does?
I think that I think that there are time constraints, meaning I think there are time limits to how long they can take.
Can somebody Google that? Because I can't.
Yeah, I can't Google it right this second, but when I get back.
I'm Googling.
All right.
Okay.
But hold on a second. They have a little while because of the fact that this isn't the only case they're
30 days
reviewing.
Okay, and that date was the 13th. Am I right on the date or wrong?
I'm not sure what date it was. It says time of decision. A motion for a new trial shall be heard and determined by the court within 30 days from the date it is filed, except upon good cause entered in the record.
Is that
Wait, read that again.
appeal?
Hold on, read that again, Mo, please.
Hold on. Had to clear my throat.
Okay.
Let me clear my throat. Okay. Time of decision. A motion for a new trial shall be heard and determined by the court within 30 days from the date it is filed, except upon good cause entered in the record.
So filed and heard, is that what it says?
It'll be heard.
Yeah, that's not
decided upon.
No, heard is what he got. They got heard.
Heard.
They got heard, but I don't know that they have. I mean, they don't have an indefinite time, but I don't know if they have like an actual factual, like, I don't know.
So Dee Dee, they're at the appellate level. This is the appeals court. So he would have to file with the Supreme Court, and the Supreme Court could decide if they will hear the case or not. So Iowa Supreme Court.
Yeah, not the U.S. I mean,
yet.
after if he exhausted all of his appeals through the state level, which would include the Iowa state Supreme, then I suppose he could petition to be heard in front of the U.S. Supreme Court. But they only hear like, I don't know, like 5 or 6 cases a year. Super hard to get in front of them.
Mandatory to do all death sentences, so they're already pretty filled with that too.
Yeah, they're not trying to hear.
I mean,
Todd
it could
Mullis.
happen, but typically stuff is solved by the state Supreme Court. So this is his first appeal. He most likely would get a second appeal with the state, and then depending on the attorney and what motions they file. But obviously, I don't know if it would ever go to the United States Supreme Court. But
wonder why they don't. If his argument at the sentencing was basically that Todd is innocent and therefore it would be unlawful to sentence him at that time. I think, isn't that a habeas corpus? So why doesn't he file an actual innocence claim? Because that's what that is.
Well, I was under the impression that that attorney felt like that was when the motion was scheduled and that they were going to be hearing.
No, I know, but just since then, why hasn't?
Oh, I don't know. That's why I was wondering what they have what they have filed.
I feel like there are other avenues available, and you can have different appeals going at the same time.
I think so
Maybe
too.
that's what's going to happen.
That's way beyond my scope of knowledge.
Yeah.
Well, wait. I don't know if that was the regular court, because remember, this is the appellate court. So this one says, under the appellate court website, the time varies depending on many factors. Cases assigned high priority, such as child custody and criminal matters, generally obtain a ruling in a shorter time frame. The court strives to provide decisions within 3 to 6 months after a case has been transferred to it by the Supreme Court. What? Supreme Court? Never mind. I didn't read the whole thing. I don't know why it says Supreme Court when it says Iowa courts. So, 30 days to 6 months, I guess.
Well, I will say this. The appeals process is notoriously slow.
Right.
Some states are faster than others. I will say this. Texas, relatively speaking, and Florida also are some of the most streamlined systems. However, they still take a long time. California, sorry, Teresa, where you would, if you were to receive the death penalty, you would be more likely to die of old age than you would of actually having your case actually receiving your penalty. They're very slow. Texas is on average, I think, like 10 years or something like that. It's pretty quick.
Well, this is my concern. So that this dude is innocent, and this is just how it goes. I don't know. I just have such a problem with this.
I know, but
it's so unsettling to me.
It's very unsettling. It's very unsettling to know that you're going to spend a good amount of time in prison. I mean, there are exceptions, right? But for the most part, generally speaking, there are lots of actual innocent people in prison right now going through this process in various states. And it's yes, Heather, whatever. They pride themselves on that. But to their credit, they're far more, their rulings are quicker, and DNA is very compelling in the state of Texas. That is one thing I will say for them. But their process is, there are some states where it's almost impossible to get an appeal. Their odds are stacked against you, really.
Right. You're almost better getting the death penalty because then you do have all kinds of appeals.
You have automatic appeals. Come on, Nestor, let's go. Yeah, you have automatic appeals, but no, Texas does not play. They do not. And you have to think about too, COVID really impacted the courts and what they can do, and how the process of it. Everything has slowed down because of COVID. So they're going to be backed up anyway, because there was a time when states were absolutely completely locked down, and all of those cases that were pending to be heard are on the back burner. So they're not gonna, and this is an unfortunate fact, but they're going to be more likely to get to try all the cases that haven't been tried versus hearing appeals. And that's just the way, and it's unfortunate, but can't think of a way to fix it.
Yeah, I'd say if he does get a new trial, it'll be a couple years at least, right?
Yeah, at least. At least.
Well,
and
we'll keep our eye on it, and any news, we'll be sure to.
Of course we will, but that 911 call is going to be really, really hard, because I promise you the next thing they're going to do is the state is going to get a hold of those jurors, and they're going to talk to them, and so is the defense. That's going to be that's probably likely the very next thing to do. And I don't think that they had cameras, but they didn't have a security company, right, Teresa? You guys, or Mo,
No,
anybody
they had like a little
remember?
Wi-Fi camera.
Yeah, it wasn't anything it wasn't Vivint or anything. There wasn't a third party monitoring it, right?
No, it was just a little security camera with the little antennas that were up in the windowsill.
Okay.
The cats didn't knock out the camera; they knocked out the antenna for the Wi-Fi.
Right. I have to say, in all of the shenanigans,
it was like a baby monitor.
I have to say, in all the shenanigans that Alice has pulled, and let me tell you, she has pulled some shenanigans. She's never messed with the Wi-Fi. Good job, Alice. Good job. She's pulled some
slit your throat when you're sleeping, but she's never.
Correct. She may tie you up in the blind cords because you didn't get her snack to her in a prompt in timely fashion, and with a smile on your face and a song in your heart. But she's not going to mess with. You'll be able to have Wi-Fi while you're tied up.
Oh, that's interesting. I just thought of that. Maybe one of the cats ran under her and she fell.
Freaking cats. That's very possible, though. I mean, ironically, it is.
It would be very. I mean, there are all kinds of scenarios.
Wouldn't it be really weird if it was the same cat that knocked out the Wi-Fi? That would be premeditated, in my opinion.
Correct.
Right.
Like if that was not the
or they banded together.
Not the Mugwise, but after they ate after midnight, and then they turned into the Gremlins. Yeah, and then there was Stripe, who sort of was the leader of the Gremlins, and he's the one that directed all the mischief. I wonder if there's a head mischief-making cat.
Maybe they wanted revenge for their mom getting ran over.
Yeah.
So they were like, okay, you go knock the cameras over.
Yeah, they were avenging their mom.
You lose your mom.
Yeah, they were avenging her, in Jaws. What is it, Jaws 2? Isn't that the one, or is it Jaws 3D? I can't remember which one it is, but they killed the mama shark, and the baby shark is who comes back for revenge.
And they positioned the rake just right, and then
he came back with the never-ending song.
What a catastrophe!
What a catastrophe! Good one, Rita. Good one. Yeah, he's gonna have to wait a while.
Get a new one. Who thinks that the appeal will be granted?
Not me. Not this first time. Not this first time.
I was hoping that it would be, because I didn't watch it, and I saw all the three, and I was like, okay, this guy seems pretty good. But now that I watch it, I'm like,
He was better at the trial level.
He would, exactly. That's the thing. He was aggressive. The other attorney would have actually served better at the appeals process.
I agree.
You need emotion during a trial. You need, for lack of a better word, you need a Spock Sheldon Cooper combo at the appeals, because these are judges, they are attorneys, they're not going to be compelled by emotion. They're going to be compelled by the law.
Yeah, I think that he's not going to get one. Yeah, I think he should.
I think you are 3 hours behind me. There'll be no yawning out of you.
I think he should too.
Yeah.
She made me yawn now.
Well,
He
at least
should get a
we're
new
almost
trial.
midnight.
Whatever. I'm old.
Listen, I don't really have a legitimate reason other than it is 11:23 at night. That's and I'm 45. I'm older. But you guys have way more reason to be tired. You have tiny humans you're taking care of. And I remember those days.
And
Tiny
they all
humans.
survived today, so I did something right.
There you go.
Yeah, you have
Isn't that the goal?
humans, so okay, you can yawn.
Yeah, but you have a tiny human and Milo, who I'm telling you.
Yeah, but we have tiny humans the same age, and then she has multiple tiny humans.
My other two aren't very tiny. I was actually just out running around all day because we're going on vacation in a couple weeks up to the mountains.
Ooh.
If you guys know anything about Southern California, I didn't even own a jacket.
There's no reason. Why would you own
why
a
would
jacket?
I own a jacket? That's just silly, right?
Correct.
So no, got to go up to the mountains and play in the snow and stuff. Well, that's like a whole new wardrobe. So I was running all over for 5 people, new wardrobe for 5 people, trying to figure out.
Does California even sell winter attire?
They have skiing.
Very few and far between, which is why I was at a lot of places.
Yeah, it's not. I mean, North California and up in the mountains, obviously, it's cold.
I have to get my heated vest.
There are places in Arizona like that too. Flagstaff, you can go to, and I think Flagstaff is like 4 or 5 hours from where I was when I was a kid in Tucson. Yeah, even when we would go to Mount Lemmon, which is technically, I think it's in Tucson. It's been a long time, but it's colder up there than it is in the actual desert of Tucson. So yeah, just because you're over here at full out,
desert.
it can't. Yeah, Arizona's got mountains too, not just desert. You know what I'm saying?
We went and stayed. I'm trying to think of the name. It starts with like a P. Oh, where the heck did we stay? But it was up in the mountains, and it was colder there. Like I had to put on my sweatshirt, at night.
And the thing that people don't realize about places like Arizona is that it's not humid. So, and people used to say all the time when I first moved to Texas, it's a dry heat. You know what else is a dry heat? A fucking oven. All right. So stand in front of your fucking oven and tell me, if I added moisture, it'd be worse. No, it's friggin' hot. It's 105 degrees. Okay. Period. It's hot. But when the sun goes down, it's a drier air. So it does cool down. It doesn't stay like Texas. I will say where I grew up in Texas in the summertime, when the sun goes down because of the humidity, it still feels 95 degrees outside. It's still hot.
Yeah.
And I don't know, Mo, if when you came, you felt the humidity here. I don't. My sister swears it. She's like, the air is thicker. I told her she was full of
yeah, I think that there's so much humidity down there. I used to run one of the Jenny Craig centers down there that I would have to go visit. Oh my gosh, and I would go in like June and July. Ugh.
Where though? Where were you?
Ocala. I would fly into Orlando and I'd drive up. Oh my god, my hair, because I have naturally curly hair. It was a flipping nightmare, man.
That's awful. I know. I feel you.
Do you know what's weird is I have naturally curly hair here all the time. I have naturally curly hair.
Just when you're there.
Okay. And the way that people talk about the humidity here, I thought I'd be running around like a whole alpaca. But I don't know if it's because I'm so close to the water that it's not as humid.
Yeah, I didn't think it was that bad when I was there, but it was in March. But here in the summertime in Virginia, it's a humidity. You can't even breathe outside.
Heather would ever had 19 feet of snow. 19 feet of snow. That's ridiculous to me.
Why are you a penguin? There is no reason for a human being to be in an environment where there is 19 inches of snow.
Also, when I went to Colorado, it didn't feel as cold as it does here. Even, with the same temperature, like 36 degrees there didn't feel as cold as 36 degrees here.
Makes sense. It's like whenever you're heating your house,
that
like
would
here.
be, Tony. I don't remember. I was young. I moved from Texas or from Arizona to Texas when I was 10.
That's
I
when I
loved
was 10
Colorado.
when I moved out to Central California, because I'm from the Midwest, so I was raised in snow.
Yeah,
And then I purposely don't want to live there. Like, I made an adult decision. Like, this is not where I'm going to spend the rest of my
life.
When I have
If
to
our
buy
country had a spot that was
bags and
warm,
crap to put in my trunk of my car
I'd
just to
go.
be able to drive, I'm like, yeah, no, this is dumb.
Yeah, I can't. It's not that I couldn't manage. I mean, obviously, when I lived in Texas and it gets cold in North Texas, I managed. I survived. Hello, I'm still here. But now that I have a choice, and there is part of me that will always miss Texas. I love Texas. I'm very proud of that state. But I don't like the cold. And the fact that I'm tripping out because it's 55 degrees right now, and I'm, trying to find socks that are thigh-high socks literally for no reason.
Sideboard just got you new socks.
She didn't get me the thigh-high socks, though.
Oh, Rita, apparently I don't know where the P came from because it was Williams. I just asked my husband. So I don't know where I got the P, but I have no idea. So just take it. It was Williams, Arizona.
So for future reference, Teresa S. is not going to be good eyewitness testimony.
No,
she
apparently
thinks
not.
P and
That
W.
would be horrible.
It's weird because I have a very good memory when it comes to certain things, and but it's like I store that stuff, and then all of a sudden, the other stuff, I literally just get rid of it. It's like, that was worthless information. Let's knock it out.
Right, stuff that I don't need to know. Okay,
I don't need to know
there
what
when Mo said, "Let me clear my throat," I almost finished that line. And I'll always, just like I was telling Shamita yesterday, to tell her little boy, hey, I know where all the, I know how you can get everything and pass every level at 100%. Why do I retain that on Mario, Super Mario? Whee! Why do I retain that? It is important. There's going to be a time when my life is going to be dependent on beating one of those levels in Mario at 100%. And guess what? I'm going to survive.
Yes,
I'm
you
going
are.
to survive.
Yes, you are. I think we retain that stuff just so we could show the kids, we knew what we were doing.
Exactly.
You think you're all big gamer with your multiple screens and shit.
Right.
Beat this.
Call me when you're trying to play some 16-bit Mario game that you can't even save. You used to not be able to save on the old regular Nintendo.
Yeah. Tell me if you can even get the damn cartridge to work first.
Right. Exactly. There's a very specific blow, shake, put in way that you have to do it. Otherwise, it's not going to work. And you don't know that.
Well, I used to jam out to Captain and Tennille on 8-track tape.
Boom.
Boom, Mo. You got me beat. I was straight cassettes and records.
I was a lot of cassettes, and I remember the first CD I ever bought with my own money, which is funny because you were talking about your first cassette you ever bought with your own money. My first CD I ever bought with my own money was Ugly Kid Joe.
Oh, really?
Yeah, no, I don't know why I like that. But that's what I want.
Everything about you.
I don't even know what an 8-track is.
Oh, shit.
Shamita, listen, Shamita was raised with penguins, okay? First of all, it's friggin' cold where she's at. It's absolutely Antarctica up there. And she's seen 3 movies. How many movies do penguins frequently watch? 3 is a lot. So I'm sure in her little penguin, what do penguins roam in?
Brain?
Your penguin pride, your penguin pack.
You were the most worldly of all the penguins with your 3 movies.
It's true though. I don't know how I've gotten through life. Like
I really don't either with your 3 movies.
and they're not even good movies.
Let me just tell you, the amount of horror movies that I've watched has kept me out of some very sticky situations, potentially dangerous situations. So, just saying.
Yeah.
Just saying.
The scariest thing I've watched in a while is the Woody guy on Toy Story when they're hiding from Sid the Kid. And he's like, "Wah-ha-ha-ha," and he's ripping them all apart. And then the fishing rod legs and stuff all start coming out. Like, even that, like, creeped me out. I don't like
Are you serious?
Yeah, no, I don't
And
like
you're
that.
a true crimer. That's hilarious.
That's what creeped you out, not the doll with one eye glued shut with spider legs.
All of
that
it.
didn't
All
freak
of
you
it. They
out.
all start coming out of the freaking dark at him. Like,
autopsy photos. Let me send you autopsy photos, but no, I cannot handle the animated baby doll legs on fishing.
Yep.
But
I'll
but
take the autopsy photos. Not this creepy shit.
What about when he spun his head around and he said,
Yeah,
"You
no, I don't like that because that's
everything."
like.
So play nice.
So I think you've never watched the Toy Story Halloween one.
Oh, that's far
I
too
never-
scary for her. What are you talking about? She couldn't even make it through regular. That was.
I just don't like that stuff. It creeps me out. Or if it jumps out at you, like, I don't like it. I like to enjoy it. I don't like to be, too afraid to eat my popcorn because I might choke if I get too scared. Like, no, thank
So
you.
Ghostbusters probably really would throw you over the edge.
Never watched. Never read. Never watched.
Red, I don't know.
I don't think it's a book, babe. So you're safe.
Oh, I thought there was a Ghostbusters book. Oh, I'm thinking of Goosebumps. I'm thinking of Goosebumps. Never read them either.
My God. Oh my God.
I feel like I need to just send you DVDs or something.
Well, this is the thing, Teresa. We've been talking about this for quite some time because I've been aware of this situation and it has not gone unnoticed, and it's a high concern of mine. And I have been saying that the minute that the Canadas are open for releasing their people to come to the United States, Shmita, I don't care how we have to get her here, is coming to Florida for an education.
It's literally a weekend of back-to-back movies.
Correct. Let me just show you. We'll watch them at 2 times speed because you can pick up everything you need to know. I can't let her go on like this.
No, you need to
I've never watched Lord of the Rings, Harry Potter, any of that. Nothing. Star Wars, I had to
oh my God. Are
double
you
check
trying?
your Star Wars stuff to make sure that it was actually.
You're trying to kill me, Shmita. I feel like you're murdering. I can hear my soul being murdered right now.
Okay, so what are the 3 movies you have watched?
Well, part of Toy Story. There's one.
I never watched that vampire movie, Edward and all that.
Oh, Twilight.
Yeah,
I watched it with my oldest daughter. She was a huge Twilight
I did
fan.
watch that. I did watch Twilight.
The first one or all of them?
She doesn't know.
At least one.
Shmita. At least all the way through, Shmita.
Do you just not like movies?
I do. I don't have. They're too long, and they need like you need to be watching it, and you need to sit, and you can't talk. You have to be quiet. Don't ask too many questions, and I don't know. I just prefer.
She prefers the tubes.
Yep.
Where she can push pause, walk away, come back, come to chat, and ask me questions about it.
She could do that with a movie.
I've tried to tell her that. Like, these will be movies that I've seen before. So I'm perfectly open to a question and answer session. Unlike my sister, who will watch a new movie that neither one of us have seen and ask me questions. Hey, Jen, why are they doing that? I don't fucking. You're watching the same thing I am.
Wait,
how the fuck am I supposed to know?
You've watched
Do I?
Tombstone,
I am.
right?
Have I?
Yeah.
Have I? You
Because
watched
you made a
Tombstone?
movie.
Okay.
You made a movie reference to me about Tombstone.
Did she say she'd be
No,
your
I didn't.
Huckleberry?
No, I didn't. I made a reference. You connected it to Tombstone, and you liked it, so I just went along with it. I was like, yeah, I did.
Are you freaking kidding me?
Oh
She
my
faked.
God.
She faked you, Teresa. Shmita, you got me questioning my whole
Shmita.
life now.
I think
You
I
did
think I
not.
said to
Did
you
you
my
really?
level of petty.
I got to go
My
back and
level.
read that now. I thought we were like, I thought it was like, that's my spirit girl right there. And she's like, yep, sure am. No fucking idea what she's talking about.
No clue.
So she
You
probably
pretend movie watched.
she probably came to chat and said, "Hey Jen, what's this mean?"
No, I didn't. I googled it.
I'm kidding. Oh
Did you
my god.
Google it?
Google Jen.
Yeah,
Same
because
thing.
I was like, what did I just quote?
Did you? Did it come up with Tombstone?
I think so. I said my level of petty knows no
Now I'm
bounds.
gonna be like, I'm gonna actually, if you try to make a movie quote like reference to me again, I'm gonna be like, what movie is that, Shmita? Before I tell you.
Yeah. Don't
Fake movie watcher.
don't give her the read technique,
Fake
Tammy.
movie watcher.
Don't give her the read technique, Tammy Lee. She can't take it. It's her little
Or I'm
heart.
gonna quiz you like, who says that in the movie, Shmita?
That's what you need to do.
I'm like, what movie?
When you watch documentaries, they're just as long.
Yeah, but you don't have to like. I don't know.
Those you actually have to pay attention to. That's kind of the point of them.
That's kind of what I'm thinking in my brain, but I wasn't going to say it.
There's no requirements of watching a movie. You don't have to sit still and not talk and eat popcorn.
Yeah, Tony, I guarantee he has no idea what that line is from.
Hold on, let me see what Tony said.
You're killing me, Smalls.
Oh yeah.
I know the quote. No idea where it comes from.
You've never even seen The Sandlot?
No. Don't. I've heard the quote.
Shmita is the kid from The Sandlot. It was signed by some woman. Babe Ruth.
Everything I thought I knew is just gone now.
Never believe Shmita again.
Imagine when she told me she'd never seen a single Harry Potter movie. I'm telling you, my heart stopped. My heart stopped. I wasn't hopeful for Star Wars. Star Wars is not for everybody. I get it. It should be a requirement, but it's not. And trust and believe when I take over the world, and one day I will, Star Wars will be part of the curriculum. I don't care what anybody says because I'll be running the world. Okay.
I rule the world.
Star Wars will be curriculum. Sure will be. And so I make song references too. And she was like, what?
My husband does that crap to me on purpose just to make me sing something. So he'll stick something in like a sentence just so that I'll finish it off with the song.
I don't listen to music.
That part of that let me clear my throat is still stuck in my chromo. I'm not going to be able to let it go.
I don't listen to music either.
See, that's the weird thing is I don't know many people who sing which songs. Like it's hard for me to place like who sings which songs, but I know a lot of singers and bands, and I know a lot of songs. I just cannot always tell you who does what.
Yeah, I couldn't.
When people ask me, they're like, "Do you know that actor in the movie?" No, I don't know that actor.
Yeah, I haven't watched a movie in a long, long time.
Well, why not, Mo? How come? You don't have to sit down and pay attention.
Let me tell you this. You cannot ask Mo about anything movie related, really. I mean, there's some movies you can, but let me tell you what Mo is excellent at. If you ask her what a contestant on Big Brother 8 on Tuesday morning, she will know what the entire fucking house ate and how much they ate of it and who wasted. Lo will tell you.
They ate chicken last night, and they put a whole bunch of sweet potatoes and rice in it, which I thought was very weird.
See?
Yeah, that is weird.
But apparently it was really good.
She'll know how many times they were at the gym and how many push-ups they did and how long they were on the cardio. She knows all the things about all the Big Brothers all the time.
Hey,
I'm
Mo,
shocked.
who starred in the movie Goonies?
Who starred in it?
Yeah.
I wouldn't know their names.
I don't even know what movie you're talking about. So
You've never seen Goonies?
You know what
You don't
movie
even
is
know
good
who's
that
in
I've
it.
seen? Coneheads. Coneheads. That
Coneheads.
movie kills me.
Really?
Yeah.
Here's the thing. Okay, if you, this is what's interesting to me. I actually like the skit from Saturday Night Live. Okay, with Jane Curtin and Dan Aykroyd. That's what I like. I wasn't a huge fan of the movie, and I find that people that like the movie don't actually like the Saturday Night Live skit that it was based on.
Sean Astin.
You Googled.
But I remembered it when I saw it.
I have no idea who's in Coneheads.
But I wouldn't have remembered his name, but I remember his face.
Well, yeah, because
I'm
he's
awful
also
with
Sam.
names.
He's also Sam in all the Lord of the Ring movies.
But they've never seen those.
Who's his mom? Patty Duke is Sean Astin's mom.
Oh, really?
Uh-huh.
He does look like her.
How about like Back to the Future? Have you guys watched that?
Yeah.
I know that there is a car called the DeLorean.
Oh, my.
Good job, Smita. Good job.
But that is as far as my Back to the Future knowledge goes.
That's Michael J. Fox, right?
Yes.
Okay, see, I didn't know
Yes.
that. And I didn't Google.
Yeah. There were
I don't
two
know. I
different
read
people that
shit,
played Jennifer in the movies, too.
I read pointless stuff and take screenshots.
Shmita,
lot
what's
of
on
stuff.
page 142 of the Watts discovery that she knows?
I've been blocking all that stuff out.
You should. I'm blocking it out too because I don't care to be. I don't want to be on that island. I don't want to have anything to do with that island or anybody that's
Everybody
even
associated to the island are.
Yeah.
I can't handle it. Like,
right? It's like
obsessed.
it's toxic. There's
That
something wrong with that island.
That case mess. This is what I really have been thinking
That's
about
the
why that case has messed everybody up. And I think why it's so psychologically traumatizing is because most crimes that occur in that fashion, there are some kind of red flag, something, right? There was nothing. And then you have, because family annihilators, while rare, they're not unheard of. It's not like Chris Watts is the first family annihilator, okay? But it's the way he disposed of the girls and Shanann. The girls more than Shanann. A shallow grave is not that uncommon. It's cruel and it's foul.
Yeah,
what
but
he
it's
did.
everything that comes after all that, and it's just.
But I think that that those circumstances are what puts people in such a jacked up frame of mind that then causes all of the things that came out after that to occur, because as nobody is in their right mind after hearing those details, because it messes you up.
Yeah.
Because they're always in almost every single documentary, the first thing they say is that the size of the opening was the size of a paper plate, and that right there is messed up.
Yeah.
And knowing, it's just those details of the case that mess people up.
And on that note, I have to hop off to go take care of a tiny person.
Okay, well, thank you, Teresa. I'm gonna get out of in this too. We're gonna be back tomorrow night. Thanks for coming, babe. Go take care of your tiny human. That's
Always. Thank you guys. Shmita, go watch a movie.
something, anything, shit.
What random one on TV, and then come tell us about it.
Yes, and I promise you, I'll be very excited. I promise, even if it's a
All right,
movie
I'll
I
talk to you guys
think
later.
sucks.
Bye,
All
ladies.
right,
Take
bye.
care. Thank you.
Bye.
Bye, babe. Bye.
Teresa was like, "Watts talk. I'm out of here."
Yeah, because I can't. I just can't believe how anyway, I don't want to talk. But I will say this. I know that the Watts case is how I met all of you guys, and well, not Mo, obviously, but Shmita, obviously, and everybody that's in chat. And so for that, I'm grateful. And I'm glad that despite all of the chaos that it caused, and at some levels is still causing, you guys can take refuge at the in the ward, because we're not going to be discussing any of that crap over here. We're just going to stick to true crime. I don't care about that other stuff.
Yeah.
So I think tomorrow night what we'll do is I'll put some stuff together of the testimony, the pertinent, relevant things that we wanted to hear, and we'll just do a good recap and good discussion, and then we'll start the Ezra McCandless case on Tuesday.
And like comment under here or whatever, you know, like if there's a certain spot that you'd like to revisit.
Yes,
And
yes,
then
yes.
that way
Thank you.
we can
So
make sure
actually,
that we post
send
that.
it to Shmita. She's the manager. If you have a problem or anything like that, and you want to speak to the manager, speak to Shmita. She's the manager.
I'll
I
get
don't
back
know.
to you in 5 to 7 business days or
I don't know if your
never.
problem will be resolved. I don't know if she'll even check the suggestion box, but she's the manager. So good luck. All right, you guys. Thank you so much for coming. I will see you all tomorrow night. Okay, bye.
Okay, bye.